It is written as 25/20/25. Here's a typical error. Accordingly, I filed application for that particular date on Friday. I was expecting that yesterday it will be listed or today, but not listed. Either Lordship will be kind enough to take the production list today or tomorrow, my lord, whatever Lordship pleasure. Tomorrow, my lord. Oh, sorry, sir, sorry.
My lord, may I pray item 16 may be taken up at 2 o'clock, my lord. I'm in the midst of a partner matter in court number 1. Item 16
Okay.
at 2 o'clock, my lord. Deeply.
May I please ask you, my lord, I beg to mention for listing contempt petition, my lord, 2017 matter, my lord. The last occasion, advocate Mr. Adhor, my lord, was instructed, my lord, to submit the instruction. My lord, last list is on 19/12/2023. My lord, may be listed next week, my lord. 2017 matter, my lord. Let's take anything. 8. Oh, like.
May I please, your lordship? I beg to mention a petition, your lordship, for listing for today production list, your lordship.
Why?
Yes, lordship. The petitioner is lordship, the constable, your lordship, under CRPF department, your lordship, and under departmental order, lordship. You will be removed from service from today, your lordship, afternoon, your lordship. And in a similar matter, your lordship, this honor, your lordship has interfered in a matter, your connected matter, your lordship. Your lordship, the department, your lordship, go beyond the authority, your lordship. The imposing authority is not the proper authority to impose that penalty, your lordship.
Have you informed the
I just called yesterday, your lordship. They just told me that survey copy. I already served a copy, your lordship. Highly organized, lordship.
I think a lot. I did mention for listing of a matter. Idea lordship. Matter notice was issued on 11th, making it returnable after 4, but matter has not been listed till date.
We'll have it on Monday.
May I please, lordship? I beg to mention for listing, my lord, contempt petition. On next week, my lord.
13.
Oblige.
Please, lordship, I beg to mention item number 35. There is lordship. Kindly adjourn this matter only for legal lordship.
Item
35 lordship.
you are mentioning on behalf of
Our Fukan lordship.
when do you want?
Adjourn for today only.
On request made on behalf of Mr. Arfukan, let us also the petition. List after 1 week.
May it please, your lordship, my lord. My lord, I beg to mention item number 33, my lord.
Yes.
My lord, today we have some personal difficulty, my lord.
Your good name?
HP Gwala, my lord.
When do you want?
Not after 4 weeks, my lord.
Request made by Mr. H.P. Gawler, then we come to the petition. List after 4 weeks you want?
My lord,
Why? 2017 matter
my lord. Then my lord, 3 weeks, my lord.
after 3 weeks.
Oblige, my lord.
Please, lordship, I am paying for listing on writ petition. Lordship, on 15 May.
When?
15 May.
Why you want the date? Okay.
May I please, my lordship? My lord, these 2 matters are not listed for more than 1 year. And these are service matters.
May.
Bless me.
May it please, your lordship. My lord, may I pray for listing of an admission matter, my lord? Next week, any date, your lordship.
10th.
May I please, lordship? I beg to mention for listing for admission, lordship.
15th.
May I please, your lordship? I beg to mention for listing, your lordship, on writ petition relating to service matter on 2/5.
Not 2. 13th.
13th.
May I please, your lordship? I beg to mention for listing, my lord, on salary allowance on 2, my lord.
15th. 15th.
May it please your lordship, I beg to mention an IA for listing, your lordship, for rectification of the order, your lordship, in disposed of matter. Kindly, it may be taken up tomorrow, your lordship.
8 May.
8. Hi, your lordship.
May it please your lordship, with the consent of the other side, I beg to mention item number 38, lordship.
30?
38.
Yes.
Mr. R. Mazumdar was appearing in this matter, lordship. He was supposed to be here today, but he's out of station, lordship.
Okay, on request made on behalf of Mr. R. Majumdar, then it's also for the petitioner. List after.
Lordship, any fixed date, lordship? On
What do you want to fix date? List after one.
obliged, lord.
May it please your lordship, my lord, I filed one writ petition on Friday, 26, my lord. I got the filing number also. There is some urgency maybe on tomorrow, my lord.
Not tomorrow, Friday.
On Thursday, my lord. Urgency is there. my lord.
What urgency is there?
Urgency, my lord, petitioner further donated some land for, my lord, construction of house under Jal Jeevan Mission on the condition that petitioner will be appointed, my lord. Now they are going to appoint some other person. Petitioner got training also by
Now
the
there will be no
department.
appointment orders, Friday.
Yes.
May I please your lordship? I beg to mention for listing, lordship, a writ petition,
17th.
7.
May I please your lordship, my lord, I beg to mention for writ petition, listing of writ petition, motion matter.
Motion matter,
Yes, my lord.
10th.
Hmm?
10th May.
10, obliged.
Item 1 to 8 of daily list.
Oh.
Your lordship may like to peruse the last order passed in WPC number 1069 of 2023. In fact, on the last occasion, your lordship will recall, the respondent number 6 had prayed for some time to get back to your lordships on certain queries. And your lordship was pleased to make an observation that in the event the matters are not disposed of, your lordship will reconsider the entry.
Who appears for 6?
6, my lord, I was informed, my lord, by the council that he's undergoing treatment. His junior was supposed to make a mention, but apparently he's not. Yeah.
What is the interim order?
Well, it's a very limited interim order. Order is dated 1st of March 2023. In fact, the interim is to this effect, my lord. However, as an ad interim measure, it is hereby provided that the post held by the petitioner shall not be filled up without obtaining the leave of this court. What had happened was, just to refresh our memories, may I just briefly indicate the fact.
Yes.
What had happened was, IOC had undertaken a selection for about 38 odd posts. After the selection was over, appointments were made. There were 2 complaints filed by 2 persons who are petitioners in item numbers 2 and 3 here. They filed a complaint saying that our ouster was wrongly done. We could not have been ousted because we were entitled to certain relaxations under the advertisement, as per the advertisement. And they also filed writ petitions, these item numbers 2 and 3. Based on their complaint, we conducted an internal investigation. And in the internal investigation, it was found that their contention is correct. The petitioners in item numbers 2 and 3. And we also, while doing this inquiry, we also found that there were 2-3 other persons in respect of whom there were some errors. So accordingly, since they were working on probation, we simply issued orders of termination simpliciter. So the other writ petitions, item numbers 1 and then 4 to 8, are those terminated persons who are before your lordship. But there is no interim order in respect of the terminations. There was this limited or interim order passed in these 2 cases, saying that these posts should not be filled up. Now, well, because of this, we have not proceeded even in respect of the other 5. If your lordship clarifies that we can go ahead with this election and it will be subject to outcome of the writ petition, then there is no one is prejudiced. and we can also have those posts filled up. And it will be out, subject to outcome of the writ petition. Because admittedly, this factual position they cannot change. The fact that there were some errors out of these 38 posts, in respect of 6 posts, there were definitely errors which were found in our internal inquiry. And based on that, we have issued terminations. They were all working on probation. So your lordship is aware of the law relating to probation as well. But, since it was at the entry level itself, there were some errors. On the merits of the issue, I am not troubling your lordship today. Let the matters be heard as per your lordship's convenience. But this interim order, because of this interim order, those 6 posts have remained vacant. We will proceed and let everything be subject to outcome of the writ petitions.
No, you may proceed with the selection, but don't declare the results.
That again, my lord, ultimately what will happen is,
Till the next date.
the
Let us see.
post
Because the
will,
issue is Mr. Fukani is going under treatment. Is undergoing treatment.
that I can understand.
So that.
If there is some medical issue, it will not be fair on my part to, in his absence.
What we can do is we can permit you to proceed with the selection. But without declaring the results. Without the leave of this.
At least that it will be one step forward.
Yes, what do you say?
And in that case, my lord, your lordship will pass this order. Your lordship will also grant us the liberty, if so advised, we may file an IA for seeking your lordship's leave to declare the results and proceed. That leave may be granted to us. That takes care of everyone's, my lord.
In fact, my lord, the order says, my lord, not to fill up the post without the leave of the court. My lord. As and when they file an application, your lordship will consider, because your lordship has to touch on the merits in the sense
So
that.
what this court is saying,
Yes,
let them proceed with the selection.
Lord.
But no.
In fact, there is no embargo in
There's no
proceed
embargo as such, but
So therefore,
showing due deference to this honorable court, we have not proceeded.
But
Your
my
lordship
lord
may
will-
clarify that position.
my lord will maintain that no filling up of the post or even elections. I'm sorry, the result should not be declared.
Okay.
And liberty may be granted to us to approach this honorable
Heard the
court by
learned
whoever.
counsel for the parties. I heard the learned counsel for the petitioners. Stop. It is submitted at the bar that Mr. B. Fukan, learned counsel for the respondent number 6, is undergoing medical treatment. Stop. Accordingly, when do you want it? How long will his treatment last? What treatment is it taking?
I'm not aware exactly. He just called me last night and he said his junior would be here.
Where's his junior? Anyway.
Lord can.
Last one.
Time may end, so
28th of May.
fine.
Let it be on 28th of May.
This is the matter on 28th of May, 2024. But in the meantime, respondents are permitted to proceed with the selection process. However, the final results shall not be declared without the leave of the state.
Without the leave of liberty.
Without the leave of this court, so you have the liberty to file.
Yes.
Let it come up, Manoj, at the top of the list, because it's always been at the top.
List down 28, no? At the top of the list.
Much of
Apply.
Item 9, motion.
May please lordship. Let's say one instruction received lordship that appeal is lordship just now I received the WhatsApp lordship. It is stated that in this regard we have verified the office records thoroughly, but no record of the receipt of the said petition is found. Moreover, annex and that the letter is stated that but the petitioner is not being office seal and receipt number of this office. Hence, it is difficult to office to testify his claim, lordship.
Now it is within their knowledge, they can take a call with.
Yeah, you can check out whether you have disposed of the AP.
As per the instruction, Lordship, now it is not found, Lordship.
Where's your appeal?
My lord, it is at page number 34, my lord. 34, Lordship. There is no office seal, Lordship. They have stated.
But then it was received on 36.
Hmm.
It is there, received on 36.
Now it is within their knowledge. Let them take a call. They have denied, Lordship. They have denied, Lordship. It is not official, hence it is not verified, Lordship.
Which office?
Officer, Lordship, it is the Lordship,
Inspector
Inspector
General
General of Police here, Assam, Jorhat, Lordship. Let them take a call, my lord. Now it is within their knowledge. That's it. 2 weeks, Lordship, granted, Lordship. If it is possible, Lordship, I will collect it, Lordship. Or your Lordship may issue notice. If they issue notice, Lordship, issue notice, Lordship.
But Mr. A.K. Barol and I counsel the discussion. Mr.
H. Chakraborty.
A. Chakraborty, Leonard,
All the respondents.
government advocate,
Government.
enters appearance and accepts notice on behalf of all the respondents. Notice and respondents are public. Respondents are allowed to file affidavit. This number 4 weeks.
Lordship, 4 weeks. Obliged. Obliged.
42 of supplementary list, motion.
May I proceed? Here the petitioner is subject to facing 2 proceedings simultaneously. One is departmental proceeding, another is the criminal proceeding in the same facts and same set of facts, same set of evidence, and same set of documents.
How do you say that?
And Lordship will find the search sheet, Lordship will find that the search sheet first, the criminal proceeding, that is page 23, Lordship will candidate. Page 20.
This is Lordship, issue notice, Lordship. There is a Supreme Court guideline also, then Lordship. There is a simultaneous proceeding can be run, Lordship. In a Paul Anthony versus the Bharat Gold Mine Cities.
Yes.
Lordship.
But not on the.
Yes, I'm on basis of that, I am.
Simultaneous proceeding can be run, Lordship.
Can you look into
Lordship at this stage.
yeah, what is Paul Anthony says? I have the document. Paul Anthony says,
Paul Anthony says, Lordship.
and the latest judgment, Lordship, I'm passing the.
DP and criminal proceeding proceed simultaneously. There is no bar, Lordship.
That is there, but there's also.
At this stage, issue notice, Lordship.
On the same set of facts and you cannot have 2.
Yes.
There are several guidelines, Supreme Court has laid down guidelines, Lordship.
Okay, heard, Mr.
PP Bolwar.
PP Baral and a counsel. Issue notice. Mr. A. Chakraborty, Leonard, government advocate, enters appearance and accepts notice on behalf of
all the respondents.
All the respondents. Stop. Notice and respondents are allowed to file counsel. Please stop the 4 weeks.
And Lordship in Paul Anthony case, Lordship, some interim, but Paul Anthony case specifically says, okay, I'm pressing this judgment, Lordship.
No,
and this is no, Lordship.
No, Paul Anthony says, if the evidence is will be highly positive.
Prayer for interim shall be considered the next week.
Okay.
Item 9 and 11 of daily application.
This is the part-heard matter, my lord, where the petitioner was dismissed without any inquiry. And although it was not pleaded, but the plea was taken that under 311(2) subsection B, my lord, the inquiry was dispensed with. In fact, the records were supposed to be produced before your lordship.
Where is Mr. P.G. Fukant?
Let it be taken after some time. I'll contact him, my lord.
Just contact.
I'll contact.
Well,
Yes.
That's it. That's it. In this case, although I took time to file counter affidavit against the additional affidavit filed by the respondent authority, the two petitioners, they are very poor boy. They could not come to Guwahati. So I prefer to submit before your lordship on the basis of the records, lordship, read petition and their affidavit, lordship, without filing the
Reply.
counter affidavit.
Will it not prejudice your case?
Let's see, the crux of the matter is that, lordship, the petitioners, they allege some irregularity in appointment of the private respondents, let's say. And those allegations are raised by one of the official that is annexed in their additional affidavit also, lordship. So those allegations are there, lordship. On receipt of the complaint of that officer,
You're not filing a reply. To the
Lordship.
additional counter affidavit.
lordship.
Will it not prejudice your case?
Because lordship, the same allegations were brought to the notice of the authority
So-
by their own official, lordship.
So you are very sure?
Lordship.
Okay, proceed.
That's it.
Halfway don't submit that, you'll file your reply again.
No, lordship. Lordship may dispose of the matter, lordship.
You're ready? Proceed.
That's it. The respondent authority, that is AGCL, they appointed 10 numbers of Sahayak and 1 number of peon, lordship.
Who is that?
Lordship. That is Annexer ENF, lordship, page 26 and 28, lordship. Page 26, total number of 9 persons were appointed, 8 numbers of Sahayak and 1 peon. And by subsequent notification, that is at page 28, another person, he has been appointed as Sahayak. So total 10, let's see, 9 numbers of Sahayak.
Yes.
And 1 peon. Let's see, the allegations are there.
This second order is also Sahayak.
Let's see, Sahayak. 1 person was appointed. Because earlier 1 person was selected, but he did not join. So this person was subsequently appointed as Sahayak.
So there's no increase in the Sahayak.
No, let's see.
8 Sahayaks.
9 Sahayak and 1 peon.
No.
Total, in total, let's see.
No, out of these 8 persons who are
Let's see,
appointed as Sahayak.
let's see, they are there.
One.
In addition to that, let's see.
Okay.
So total 9 Sahayak and 1 peon, let's see. Now the petitioners, they came to know that, let's see, we page, para 9 of page 8, let's see, of the read petition.
Yes.
May I read, let's see. The petitioner state that on coming to know about illegality committed in appointment of one Sri Jugal Chandra Fukan, here respondent number 15, let's say, as Sahayak, the petitioner number submitted a complaint.
Yes.
by research post to the managing director, AGCL, with a copy to the chairman, stating that Sri Jugal Chandra Phukan is medically unfit for the post of Sahayak as he uses external urinary bladder. He is too weak and even cannot work smoothly. Earlier, his service as electrician was terminated from so-and-so due to his medical disqualification. So this was the allegation against respondent number 15, Lordship. He was appointed as Sahayak. Then, Lordship, we kindly turn to page 10.
Yes.
Paragraph 14, Lordship. The petitioner state the documents received by the petitioner number 1 from AGCL and Board of Secondary Education Assam as per his RTI applications reveals that besides the medical unfitness of Sri Jugal Chandra Phukan, there are some other illegalities committed by the respondent authority in selecting the candidates for the post of Sahayak and peon. The school living certificate of Sri Anand Sarkar, he is here respondent number 12. Dated so issued by the headmaster Bordupi Janajati High School shows that his date of birth is 30/12/81 and he left the school in 1996 after getting promoted to from class 8 to class 9. On the other hand, as per certificate issued by the headmaster, so-and-so school, the date of birth of Sri Anand Sarkar is 31/6/84. So there is differences in their date of birth. This respondent number 12 regarding respondent number 12, his date of birth is different, let's say. And he passed final examination of class 7 in 1997. And Sri Anand Sarkar submitted an application for registration in AGCL stating his date of birth as 36/84. Further, the employment exchange registration certificate produced by Sri Anjan Hazarika. He is respondent number 11, let's see. Anjan Hazarika reveals that his date of birth is 1/1/1974, which is in tempered state. Sri Anjan Hazarika also submitted a certificate issued by the headmaster and secretary, Pavur High School, where his date of birth is 1/12/1974. On the other hand, the date of birth of Sri Anjan Hazarika is 1/1/1972 as intimated by the Board of Secondary Education Assam. So these are the allegations brought to the notice of the authorities by the petitioners, let's see. Then another allegation, let's see. That is page 13, let's see. Paragraph 18.
Yes.
That the petitioner state that the respondent authorities did not publish any local notice for recruitment of Sahayak and peon. Although as per rule, it is necessary to publish notice in the local office for the local candidates working under contractors in that area. Further, the examiner number 6 and 7 did not allot any marks by 7 to 17 numbers of candidates. This was done only to appoint Sri Dhantimani Kotoki, respondent number 14, illegally by showing favors. So these are the main allegations brought by the petitioners. Now, Lordship may take up their additional affidavit, Lordship. Although they earlier filed affidavit, but those were not counted directly, Lordship. In the additional affidavit, Lordship,
Counter.
additional affidavit filed by the AGCL. Respondent number 2 to 5, Lordship. Here they have annexed one complaint that is at page 79, let's see. This complaint was lodged by one official after retirement, let's see. That's it, page 79, and it's a B. Para 4, let's say I'm reading. That sir, after joining of Sri Jugal Chandra Fukan, I noticed some abnormalities in his physical fitness. He could never climb on ladder or tower during maintenance work of substation. He was only standing near working place. I verbally complained to the then resident engineer, Sri so-and-so, but his reply was that he was appointed by board. I also noticed that while he was sleeping, Sri Fukan urinates in bed and he regularly sleeps out of the mattress. He never used gents urinal and always used Indian type commode. After returning from bathroom, one sharp smell of medicine came out. I was sure that he suffered from urogenital problem. So this was the complaint by the officer under whom this person worked, let's see. Therefore, let's see, para 5, that sir, regarding illness of Sri Jugal Chandra Fukan, I asked all Sahayaks, and from them, I came to know that Sri Fukan failed to complete his run during physical test held at Tezpur. He failed to run and urinated during physical tests. So these are the complaint, Lordship, against respondent number 15, Lordship. Now, Lordship, I'll take your Lordship to page 80, para 9, Lordship.
Yes.
Para 9. That's one Sri Anjan Hazarika placed an application for a post of Sahayak. His application is enclosed here with, which is self-explanatory. That is not annexed with this additional affidavit, let's see. This is an erroneous application because its heading was Officer of AGCL. But learned executive engineer Sri so forwarded Anjan Hazarika's application to the Deputy General Manager so with an experience certificate without mentioning period of experience. The experience certificate is enclosed herewith as Annex 9. Further, it is notable that construction of so was done by Northeastern Cable and Contractors Private Limited. Mr. so was project manager during construction period. So did neither disclose verbally nor officially regarding recruitment of Sahayak and peon for that substation in any newspaper, notice board, or any advertisement, media, and in fact, he deprived all local youths who were working during construction period for a fair chance of applying for the post of Sahayak. So no local candidates were notified, Lordship. That was allegation made by the petitioners also. Sahayak and peon as departmental candidates. Sri Anup Singh, this is Lordship petitioner number 2, who was also an applicant, placed an application for the post of peon. He produced an experience certificate from Nikon. His experience certificate is enclosed herewith. There was a resident engineer who was in charge of the grid substation. His name was so-and-so. Next, Lordship, I'll take your Lordship to para 10, Lordship. This is regarding birth certificate of Sri Anjan Hazarika, Lordship. See, submitted a fake SSLC pass provisional certificate bearing serial number so and
Basically,
so.
basically complaint is that one, this Anjan Hazarika or that Fukan.
That's it.
He is not physically fit.
No, that is Fukan, let's see.
Yeah, that's Fukan.
Let's see.
And there are other two.
And this,
Other,
let's see.
they have submitted wrong.
Fake document regarding their date of birth. Let's
So
see.
complaint is against only 3 of them.
No, let's see. And other complaints are also there, let's see. They are not allotting marks to some candidates. Then let's see.
So not allotting marks to some candidates. So
Let's see, by two examiners, let's see.
how are you agree?
Let's see. After filing RTI application, the petitioner was furnished with those seats. Let's
No,
see,
no, but
which,
then how are you agree?
which,
Is those persons who did not get the marks, they will
let's
be
see.
the aggrieved
Let's see,
party?
the petitioner was also in that group, let's see. Let's see, I'm showing this. One of the petitioner, he suffered due to non-allotment of, let's. Let's see, may kindly turn to page 21 of the writ petition, let's see.
Yes.
Here, let's see. On the left column, name of the candidates, let's see. The P15, name is Anuk Singh. He is the petitioner number 2, let's see. And he applied for the post of peon, let's see. Here, in the column 1 to 7, column number 6 and 7, marks were not allotted, let's see. By 2 examiners, 6 and 7.
Yes.
And after receiving the complaint of the officer, let's see, they made inquiry. Inquiry means they examined the earlier documents only, let's see. They did not send the person against whom physical fitness is under question, let's see. He was not placed before any board, only examined his earlier certificates, let's see. And that certificate said he is fit, let's see. I said their inquiry report is at page 86. Alexa D to the additional affidavit. Let's say may kindly turn to page 87. That is a finding, that's it. As per information received from so-and-so, dated 16/3/2022, let's say. That is the complaint of the medical fitness certificate of Sri Fukan bearing serial number so-and-so issued on 25/2/2011, let's say. So that certificate was of earlier period, let's see. On receiving complaint, he was not placed under before any medical board, let's see. Only this certificate is verified, let's see, to be authentic.
That is the issue I was asking you.
Let's see.
This report is in the additional affidavit.
Let's see.
You are not filing a reply. That means you have accepted this report.
No, let's see, since the petitioner could not come, let's see, to Guwahati, let's see. And
this is the problem.
Let's see.
When you don't counter the additional affidavit,
let's see,
then you have accepted this report. So once the report is accepted, then there's nothing survives in the writ petition.
let's see, I am submitting verbally, let's see.
How can you do
Let's
that?
see.
How can you do that?
Because I cannot produce any medical certificate, Lordship. I cannot place the person concerned before any medical board. I don't have that right, Lordship. Only your Lordship may direct the authority to place the person before medical board.
How was the medical fitness certificate issued?
My lord, in fact, I am appearing for response number 11. She's for the AGCL, my lord.
Okay.
But in any case, I have gone through it, my lord. The competent authority issued this certificate, my lord. Apart from all, my lord, this is a PIL, in fact. This is not a writ petition, my lord, for this, because, my lord, the petitioner, my lord, did not mention in this writ petition how he is affected by this appointment, because they were not at all applicant to any of the posts, my lord.
Was there an advertisement?
My lord, for a long time, these persons were, my lord, Sahayak, my lord, this is a manual labor, my lord, only for my lord. These Sahayaks were, my lord, who were working for a long time, my lord. My lord, they were absorbed, my lord. Regularly, earlier, they were paid, my lord, monthly, daily basis, my lord. Subsequently, they were given the regular monthly payment. And that is the process they initiated, my lord. And the process was initiated in the year 2008, my lord. And appointment was given in the year 2010-11, my lord. And they came before this honorable court 2016, my lord. And now already 13 years, my lord, over, my lord. They are in service, my lord. An inquiry was done, my lord, the selection process was there, my lord. And the petitioner, there is no grievance against, my lord, that they were, my lord, in the fray. Their case did not consider, instead of their case, my lord. They have said, my lord, so far Sahayak is concerned, in fact, no educational qualification is required. And according to the petitioners, my lord, they are ITI pass, for which post they are eligible, whether peon post or other post, my lord. And they have not applied, my lord. How they are affected? And the person who are working for a long time, my lord, they have been absorbed.
According to you, these people are not fresh appointments, but
Yes, yes, yes. After long
yes,
time.
EAGCL, what do you say on this?
Yeah, Your Lordship, in our additional affidavit, Your Lordship.
That inquiry is also, my lord, there.
Yeah, Annexure D, we have mentioned everything, Your Lordship. The allegation they have made against the person, we have clarified each and every one, Your Lordship. Annexure D, Your Lordship. Regarding the number 1, Jugal Chandra Fukan, Anjan Hazarika, Ananda Sarkar, and each and every one.
There was a selection process?
Yes. Yeah. They have been working since long. They've been working since long, Your Lordship.
No, they've been working since long.
Yeah.
And then there was a process for observation of their.
Yes. Yes.
Where's that process?
It's one number 2.
See, Madam Devi,
Let's see.
I think you need to file a reply. You try to make an attempt.
Let's see.
You need to file a.
Let's see.
I'll give you some time.
Let's see.
Otherwise, inquiry report indicates something else.
Regarding the date of birth, the fake document, let's see,
Fake document, date of birth,
let's see.
unfit
They have
for
admitted that it is typographical error.
That is the,
Let's see.
that we have seen. So I'll give you one more chance.
Let's
You file an affidavit.
let's
Let us see what happens.
Short date may be given very old method.
MSA Devi Learned Council for the petition is allowed under another.
I leave it to your lordship. 4 weeks.
I'll give you 3 weeks time.
That's it.
3 weeks time to file reply to the additional affidavit filed by the respondents to file. Okay. You want a date fix?
Let's if we fix a date.
Give a date after 3 weeks.
3 weeks.
22nd,
27th.
22nd, 22 May.
Second.
Apply.
No,
Apply.
not 26. Let it be 27th.
Apply. Apply.
I think 10 and 11.
Furkan, you have the reports?
Yes.
Yes, Father?
My lord, on that day, my lord, I have not concluded my part. So, my lord, my submission may be, my lord, part.
Let him recapitulate.
My lord, initially, my lord, the first limb of my argument was that even a temporary worker is entitled to the protection under Article 311(2) if the order by which he has been terminated is not a termination simpliciter, but a stigmatic order. Now, in my case, my lord, just one page, if your lordship kindly sees, my lord, the impugn order is at page number 38. Page number 38, my lord, is the impugn order. And I'll not trouble your lordship with the entire order, just the last two, second last paragraph, my lord. It says, moreover, the entry of above 3 persons is restricted inside the GU campus henceforth. So, my lord, they not only, my lord, terminate me, they even go to the extent of restricting my entry into the campus, which in itself shows, my lord, that this is an extremely stigmatic order. And my lord, in this connection, my lord, I have already placed the case laws before your lordships. Those case laws were, my lord, firstly, I had placed my lord Purushottam Lal Dhingra.
What?
My lord.
Yes, those.
I placed my lord Purushottam Lal Dhingra. Just to refresh our memory, my lord.
Yes.
My lord. My lord, I had placed, my lord, the Purushottam Lal Dhingra, just to refresh our memory. Only one paragraph.
You're on the IU or the writ petition?
My lord, writ petition, directly on the writ petition, because an order was passed wherein it was stated by this honorable court that the matter will be taken up, my lord, for final, my lord, final decision, my lord. Already there is one order, so therefore I'm, my lord, on the main writ petition only, my lord.
Which case? Procedural.
My lord, Purushottam Lal Dhingra, my lord, AIR 1958 SC 36, my lord. Paragraph, my lord, 37, my lord. I'll just read out that paragraph just to refresh our memory, my lord. Para 37. May I just read out, my lord, the relevant lines, my lord? Paragraph 37, my lord.
Yes.
The position may therefore be summed up as follows. Any and every termination of service is not a dismissal, removal, or reduction in rank. Now, if your lordship kindly skips to the line starting from in short,
Yes.
it says, in short, if the termination of service is founded on the right flowing from the contract or the service rules, then prima facie the termination is not a punishment and carries with it no evil consequences, and so Article 311 is not attracted. But even if the government has by contract or under the rules the right to terminate the employee without going through the procedure prescribed for inflicting the punishment of dismissal or removal or reduction in rank, the government may nevertheless choose to punish the servant. And now this is very important, my lord. If the termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment. And the requirements of Article 311 must be complied with. And they say, my lord, as already stated, if the servant has got a right to continue in the post, then unless the contract of the employment or the rules provide to the contrary, his services cannot be terminated otherwise than for misconduct, negligence, inefficiency, or good and sufficient cause. Now, this is again important. A termination of the service of such a servant on such grounds must be a punishment, and therefore a dismissal or removal within Article 311, for it operates as a forfeiture of his rights and he is visited with the evil consequences of loss of pay and allowances. It puts an inedible stigma on the officer affecting his future career. In my case also, my lord, I am not only dismissed from my service, my lord, they're restricting my entry into the campus, meaning thereby my future employment is barred. That is the, my lord, level of stigma that has been attached in the impugned order. And if your lordship kindly turns to the next page, my lord, the next page
of
the same judgment, next page of the same judgment, and if your lordship sees, my lord, the line starting from the use of expression, it says, my lord, the use of expression terminate or discharge is not conclusive. In spite of the use of such innocuous expressions, the court has to apply the two tests mentioned above, namely, number one, whether the servant had the right to the post or the rank, which I had, because I had, my lord, secured this employment through a valid selection process via an advertisement. In the meantime, my services were also regularized, my lord. And number two, whether he has been visited with evil consequences of the kind herein referred to above. So, my lord, in the case, if the case satisfies either of the two tests, then it must be held that the servant has been punished and the termination of his service must be taken as a dismissal or removal from service, or the reversion to his substantive rank must be regarded as a reduction in rank. And if the requirements of the rules in the Article 311, which give protection to the government servant, have not been complied with, the termination of the service or reduction in rank must be held to be wrongful and in violation of the constitutional right of the servant. My lord, in my humble submission, my lord, both these tests I have satisfied. Firstly, I had a right to the posting question. And secondly, my lord, I have been visited with evil consequences. The impugned order not only terminates me, my lord, it puts an inedible stigma on my career. I cannot even enter the campus, my lord. One of a kind. It cannot be more evil than this, my lord. And my lord, in the next case law, my lord, I'll be relying on is Majid Ansari, my lord. That I'll upside down. Majid Ansari. And
give the citation.
My lord, citation is, my lord, Manu Patra, Majid Ansari versus Union of India, 1997, IILG 329 GAU, my lord. Majid Ansari, my lord. Our own High Court has, my lord, referred, my lord, followed Purushottam Lal Dhingra. Only two paragraphs, my lord, relevant only. Paragraph 12, my lord. Paragraph 12, my lord.
Yes.
Paragraph 12, my lord. From the decision cited above, law regarding removal, dismissal, or reduction in rank of a public servant is very well settled. Even in the case of a temporary worker, it is the duty of the court to see the manner and circumstances under which the order of termination was made and consider as to whether it is a case of termination simpliciter or by way of a punishment or with stigma. The order of termination or removal may be very innocuous on the face of it, but it should be the endeavor of the court to look into the circumstances under which the employee was removed from service. It can be found from the relevant records or from the other materials, the actual nature of the order of termination. And my lord, if your lordship kindly skips to paragraph 14, my lord, here also, my lord, from the above facts and circumstances of the incident case, it is abundantly clear that the termination of the petitioner was not a termination simpliciter, but a termination with stigma, and also by way of punishment. Therefore, procedure prescribed under Article 311(2) must be followed. Here also, my lord, temporary worker, but then this honorable court said that, my lord, if it is stigmatic, my lord, Article 311(2) will be, the protection will be granted to the, my lord, temporary employee. And my lord, the next case law, my lord, which have been referred is, my lord, DM Beliappa. Citation is 1979 1 SCC 477. 1979 1 SCC 477, my lord. The manager, government branch press and others versus DM Beliappa. Here also, my lord, a temporary worker. And this is what the Honorable Supreme Court had to say. I will not trouble your lordship with, my lord, the entire judgment, only the relevant portion, my lord. Paragraph, my lord, paragraph 18, my lord, paragraph 18, may I just read out? Mr. Berappa's first contention is that Articles 14 and 16(1) of the Constitution have no application whatever to the case of a temporary employee whose service is terminated in accordance with the terms and conditions of his service, because the tenure or the duration of the employment of such an employee is extremely precarious, being dependent upon the pleasure and discretion of the employer state. In our opinion, no such generalization can be made. The protection of Articles 14 and 16(1) will be available even to such a temporary government employee if he has been arbitrarily discriminated against and singled out for harsh treatment in preference of his juniors. It is true that the competent authority had a discretion under the conditions of service governing the employee concerned to terminate the latter's employment without notice, but such discretion has to be exercised in accordance with reason and fair play and not capriciously. Bereft of rationality and fairness, discretion degenerates into arbitrariness, which is the very antithesis of the rule of law on which our democratic polity is found. Arbitrary invocation or enforcement of a service condition terminating the service of a temporary employee may itself constitute denial or equal protection and offend the equality clause in Article 14 and 16(1) of the Constitution. And my lord, the relevant portion your lordship will find, my lord, operative portion, page paragraph 28, my lord, the last page. Paragraph 28, my lord.
Yes.
In the absence of any information from the appellant indicating that the respondent was marked off for discharge on the basis of an intelligible differentia, having a reasonable nexus with the object of maintaining the efficiency and integrity of the public service, we are constrained to hold in agreement with the High Court that the impugned order suffers from the vice of unfair discrimination and is violative of Articles 14 and 16(1) of the Constitution. My lord, one of the, my lord, the principles of natural justice, which has been ingrained in Article 14 and 16, is to, my lord, at least serve a show cause notice containing the charges against which an employee is sought to be terminated. In my case, my lord, no show cause, no inquiry, nothing, my lord. So therefore, it is not only violative, the impugned order is not only violative of Article 311(2), my lord, it is also violative of Article 14 and 16. It cannot be the plea of the respondents that Article 311(2), 14 and 16 does not apply to temporary workers, my lord, in light of the decisions of the Honorable Supreme Court, my lord. The decisions which I placed, and my lord, this proposition of law of DM Beliappa has also been, my lord, followed by our own High Court, Sujata Nath, my lord. Sujata Nath, 2019 5 GLT 774. I'll only point out the relevant paragraphs, paragraph 11, 12, my lord. My lord. Sujata Nath.
2000?
My lord, 2019 5 GLT 774. Sujata Nath versus State of Assam, my lord. Honorable Justice, my lord. SK made his judgment, my lord. Sujata Nath, my lord. 2019 5 GLT 774, my lord. At the top, my lord.
No, that judgment is not.
That is not there. My lord, in that case, I'll give my copy only, my lord. I have marked it. Or your lordship can, my lord, this followed, my lord. In Sujata Nath, they have followed.
Give the citation.
My lord, 2019 5 GLT 774. And the Diembeliapa's judgment has been referred and followed in paragraphs 11, 12, and 13. I've given my own copy, my lord. Paragraphs 11, 12, and 13. That they've held that even a temporary worker is also entitled to protection under Article 14 and 16.
Yes.
My lord. My next case law would be, my lord, Pavendra Narayan Verma, my lord. Pavendra Narayan Verma. A copy has been given. Pavendra Narayan Verma, which defines what exactly we mean by, my lord, stigma. I'll just point out the relevant, my lord, portion, my lord. Paragraph 10, my lord. Paragraph 10. Paragraph 10, my lord.
Yes.
Paragraph 10, it says, my lord, since Dhingra is the Magna Carta of the Indian civil servant, although it has found diverse judicial trends difficult to be disciplined into a single, simple, practical formula applicable to termination or of probation of freshers and of the services of temporary employees, we have thought it best to refer to the facts of Dhingra's case to be understand what exactly was meant by the court. And they have, my lord, quoted a paragraph of Dhingra's case. And, my lord, there's a line starting from in short. My lord, first, second, third, fourth, fifth, sixth, seventh line, my lord. In short, if this termination of service is founded on the right flowing from the contract or the service rules, then prima facie the termination is not a punishment and carries it with no evil consequences. And in the last three lines, if the termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment and requirements of Article 311 is to be complied with. And, my lord, paragraph 13, my lord. Paragraph 13 at the bottom, my lord. It says,
yes.
Another constitution bench of this honorable court in Benjamin AG versus Union of India explained the decision of Parshuttam Lal Dhingra. It followed the test mentioned in Dhingra's case. The two tests, my lord. I've already, my lord, pointed out. Number one, whether the temporary government servant had the right to the post or rank. In my case, yes, because I have secured the employment through a valid selection process by advertisement. And number two, whether he has been visited with evil consequences. In my case, my lord, it cannot be more evil. I am not only, my lord, terminated from my service. I have been, I cannot even, I'm barred entry, my lord. So my future employment is also, my lord, affected. So paragraph 14, my lord, the next paragraph. If punishment were restricted to evil consequences, the court's task in deciding the nature of an order of termination would have been easier. Courts would only have to scan the termination order to see whether its expressly contains the stigma or refers to a document which stigmatizes the officer, in which case the termination order would have to be set aside on the ground that it is punitive. In these cases, the evil consequences must be assessed in relation to the blemish on the employee's reputation so as to render him unfit for service else, whether or and not in relation to the post temporarily occupied by him. This perhaps is the underlying rationale of the several of the decisions on the issue. And, my lord, I'll directly come to the main paragraph, paragraph 29. Paragraph 29, my lord. Paragraph 29 says, before considering the facts of the case before one further seemingly intractable area relating to the first test needs to be cleared. What language in a termination order would amount to a stigma? Generally speaking, when a probationer's appointment is terminated, it means that the probationer is unfit for the job, whether by reason of misconduct, ineptitude, whatever the language used in the termination order may be. Although strictly speaking, the stigma is implicit in the termination, a simple termination is not stigmatic. A termination order which explicitly states that what is implicit in every order of termination of a probationer's appointment is also not stigmatic. The decisions cited by the parties and noted by us earlier also do not hold so. In order to amount to a stigma, the order must be in a language which imputes something over and above the mere unsuitability for the job. Well, had the impugn order, these last two lines are very important, my lord. Had the impugn order have stated that, my lord, I am not suitable for the job. End of the matter, my lord, I had no right before your lordship. But it doesn't say I'm unsuitable for the job. It not only terminates me, it goes to the extent of saying I'm not even allowed entry into the campus, my lord. It cannot be more stigmatic than this, my lord. So my lord, it falls within the definition of stigma, and therefore the protection given by the Constitution of India under Article 311 to 14 and 16 has to be granted to me, my lord. I have that protection under the Constitution. That is my humble submission. And my lord, the last case law on the issue, my lord, Surojit Bormon, I have placed a coordinate, it's a judgment of the coordinate bench. This is latest judgment, my lord. It is not, I think, reported as of now. Now, page number 8, my lord. A batch of writ petitions of the of certain, my lord, contractual workers in, my lord, PNRD. They had assailed their termination order. Paragraph 8, my lord, second paragraph, my lord. Page number 8, my lord, second paragraph, my lord. Page number 8, my lord. May I just read out, my lord?
Yes.
The petitioners in this batch of writ petitions were engaged under the Panchayat and Rural Development Department, Assam, on contractual basis as accredited engineers, computer assistant, Gram Rozgar Sahayak. However, their services were terminated by orders under challenge in the respective writ petition by giving them 1 month salary in lieu of the notice on the ground that the preliminary inquiry conducted against the petitioners had disclosed irregularities committed by them in course of their service. The orders of termination have been challenged primarily on the ground that those have been issued in violation of principles of natural justice. And if your lordship kindly turns to the next page, that is where the operative portion lies. The next page, the second paragraph, I mean the third paragraph, my lord, the line starting from, however, what is to be noted, my lord. Has your lordship got it, my lord? Fourth, page number 9, my lord. Page number 9, third paragraph, line starting from however, my lord. However, what is to be noted? Has your lordship got it, my lord? However, what is to be noted herein that a bare perusal of the impugn order of termination demonstrates on the face of the record that the same was issued on the basis of findings of the inquiry proceeding conducted behind the back of the petitioner, wherein it had been projected that the petitioner was guilty of misconduct. Therefore, the order of termination of the petitioner dated so-and-so is not only based on allegation of misconduct, but the same is also stigmatic on the face of the records. In other words, the impugn order of termination dated so-and-so was founded on allegation of misconduct. However, the petitioner was not given any opportunity of being heard in the matter. Therefore, it is a clear case where the respondents have acted in violation of the principles of natural justice. The order of termination from service issued to the petitioner has the trappings of an order of dismissal removal. Therefore, such an order could not have been issued without giving the employee an opportunity of being heard, even if the same pertains to a temporary or contractual employee. This is for the simple reason that such an action, besides causing serious prejudice to the interest of the employee, would also have a bearing on the prospect of his future employment. Situated thus, this court is of the unhesitant view that the order of termination dated so-and-so is unsustainable in the eyes of law. This is also a temporary worker, my lord. So, my lord, all these decisions, my lord, point out that merely because he is a temporary employee, my lord, he will not be deprived of his rights. In my case, your lordship had seen the impugn order 25/9/2021. I was arrested, and immediately based on my arrest, They had terminated me with an extremely stigmatic order without even holding any inquiry. And my lord, if I may just draw your lordship's kind attention to the rules, the service rules. Guwahati University service rules, my lord, I have placed the other day. The procedure of inflicting a major penalty has been stipulated in the rules, my lord. If your lordship sees, my lord, procedure for imposing penalties, rule 48. This is, my lord, Guwahati University Employees Service Condition Conduct and Appeal Rules 1970, my lord. Rule 48, my lord. Guwahati University, page number 24 at the bottom, my lord. Page number 24.
Yes.
The procedure has been stipulated. It is their own rules, the department's own rule, my lord. Procedure for imposing penalty, number one, my lord, no order imposing on an employee any of the penalties specified in Rule 46. Now, Rule 46, my lord, lays down the types of penalty, and it includes dismissal from service. So my penalty falls under Rule 46. Specified in Rule 46 shall be passed except after an inquiry held as far may be manner in the hereinafter provided. And number two, my lord, the disciplining authority shall frame definite charges on the basis of allegations held together, and the same shall be communicated in writing. And my lord, these are basically perimeteria with our discipline and appeal rules 1964, my lord. That show cause, inquiry report, ECIL judgment, everything is incorporated. Now, my lord, impugn order of termination was issued in complete, my lord, violation of this procedure. The rule of the Guwahati University itself was violated with all impunity, my lord. Therefore, on the impugn order of dismissal is also liable to be interfered with on the ground of being, my lord, violative of Rule 48 of Guwahati University rules, apart from Article 14, 16, and 21 and 311(2). The entire rule have been violated with all impunity, my lord. And my lord, lastly, just to, my lord, place, these are all settled and your lordship is all aware. Just to satisfy your lordship, my lord. Just three judgments. So it is admitted in my case that there was no inquiry, no show cause, nothing. The impugn order of dismissal was issued at the ipse dixit of the authorities. And my lord, during the course of the hearing, my learned senior friend had taken a plea, although it has not been pleaded in the affidavit in opposition. It has been orally urged that the authority had felt that it was not reasonably practical to hold such inquiry. Although it has not, your lordship will not find this plea anywhere in the pleadings. This is an oral argument they have made. And on that issue also, my lord, if your lordship kindly takes, I'll just place out Reena Rani. This is a, my lord, Supreme Court, my lord, 2012 10 SCC, my lord, 215. I'll just point out. Paragraph 8, my lord. Reena Rani, my lord. Assuming that the plea taken by my learned senior can be accepted without any pleadings. Assuming, my lord. Then also it is not liable to be, my lord. Paragraph 8, my lord. Reena Rani, 2012 10 SSC 215. Paragraph 8, my lord. In the order of dismissal, the superintendent of police has not disclosed any reason as to why it was not reasonably practical to hold regular departmental inquiry. In my case also, my lord, in that dismissal, impugn order of dismissal, there is absolutely no mention as to why a regular inquiry could not have been held. The learned additional advocate general fairly stated that the order of dismissal does not contain the reasons as to why it was not reasonably practical to hold regular departmental inquiry against the appellant. And paragraph 9, my lord. paragraph 9, in view of the above, we hold that the learned single judge and the division bench of the High Court committed serious error by negating the appellant's challenge to her dismissal from service without inquiry. The division bench of the High Court did not examine the issue in a correct perspective and made general observations that each case is required to be decided on its own facts, and no straight jacket formula can be adopted to decide whether it is reasonable and practicable to hold regular inquiry for imposing major penalty of dismissal from service. Such general observations could not have been made basis for approving her dismissal from service without inquiry. And my lord, Tulsiram has been referred and Tulsiram has been quoted. If your lordship kindly turns to the next page, paragraph 134, sixth line in paragraph 134, my lord. The line starting from it would. It would, however, be better to record the reason in the final order in order to avoid the allegation that the reason was not recorded in writing before passing the final order, but was subsequently fabricated. The reason for dispensing with the inquiry need not contain detailed particulars, but the reason must not be vague or just a repetition of the language of clause B of the second proviso. For instance, it would be no compliance with the requirements of clause B for the disciplinary inquiry simply to state that he was satisfied that it was not reasonably practical to hold any inquiry. So they have to record the reasons. And in the final order of the impugn order, my lord, your lordship will not find any mention that regular inquiry is not necessitated. In fact, in the affidavit in opposition also, my lord, there has been absolutely no mention that a regular departmental inquiry is not required. This is an oral submission which has been developed during the course of the arguments by my learned senior, and therefore it ought not to be entertained, my lord. And if your lordship kindly turns to the next page, Tulsiram has again been quoted, page 1, paragraph 135, my lord, next page of the same judgment, 135, seventh line from bottom, paragraph 135, the line starting from if the reasons are not communicated, my lord. If the reasons are not communicated to the government servant and the matter comes to the court can direct the reasons to be produced and furnished to the government servant. And if still not produced, a presumption should be drawn that the reasons were not recorded in writing and the impugn order would then stand invalidated. So they have to show, to avoid the allegation that the reason was subsequently fabricated. So they have to show the records. And my lord, I'll not trouble your lordship in any more judgment, just two last judgments of coordinate benches on this issue, my lord. Mohammed Hussain Ali, the next judgment, my lord, 2022 5 GLT 263. Mohammed Hussain Ali.
Yes.
My lord. Paragraph 15, my lord. If your lordship kindly turns to paragraph 15, my lord. Paragraph 15. In paragraph 15, my lord, the ratio of the various judgments, including Tulsiram, were quoted. And I'm only on the main issue. Paragraph 15, subparagraph 6, my lord. Subparagraph 6. Writing reason for satisfaction that it was not reasonably practicable to hold the inquiry contemplated under Article 311 is a constitutional obligation, and if such reason is not recorded in writing, the order dispensing with the inquiry and the order of penalty following thereupon would both be void and unconstitutional. And the next page, paragraph 18, this is the operative portion. The impugn order of dismissal nowhere reflects any satisfaction that it was not practicable to hold an inquiry. No assessment even was made to come to such a conclusion. No separate reason in writing for dispensing with the inquiry were recorded or preceded the order impugned. Therefore, this court unhesitantly holds that while issuing the order of dismissal, the respondent authority has failed to perform its constitutional obligation under Article 311 of the Constitution of India, inasmuch as without there being any reason in writing dispensing with the regular inquiry contemplating with Article 311(2) and Rule 66 of the Police Manual, the petitioner could not have been dismissed from service, and therefore the impugn order that so-and-so is set aside and quashed. So that order also has to reflect, at least the affidavit should have reflected that they're dispensing with the regular inquiry for so and so reasons. This is an argument which was developed during the course of the oral arguments. It was never pleaded. Basically an afterthought, my lord. And my lord, the last case law, I'll not trouble anymore. Ruben Kolita, my lord, the last case law. 2000, my lord, this is also a latest judgment. Only 2 paragraphs. I'll not trouble your lordship, my lord. The last paragraph 17 and 18, my lord. Ruben Kolita. Paragraph 17 and 18.
Yes.
Coming to the facts of this case, as noted above, the reason as to why the disciplinary authority had felt that it was not practicable to hold an inquiry against the petitioner had been recorded. Now, in this case, it was recorded, my lord. Has been recorded in the impugn order dated 31/8/2020, and the same has been discussed herein above. Applying the ratio of the decisions referred to in the foregoing paragraphs to the facts of this case, this court is of the opinion that the reasons recorded into impugn order were neither adequate nor relevant for the authorities to invoke clause B of article 311(2) read with section 11 of the CRPF Act and rule so and so of CRPF rules and dismiss the petitioner from service. For such reasons, my lord, the impugn order was interfered with. So, my lord, that impugn order should not only contain the reasons for dispensing with a regular inquiry, those reasons will have to be adequate as well as relevant, my lord. Merely, even in my case, they have not mentioned, neither in the affidavit nor in the impugn order, they have mentioned that the regular inquiry is dispensed with. But even assuming that there are reasons recorded in writing, those have to be adequate and relevant, my lord. So therefore, my lord, in sum and substance, my lord, this impugn order dated, my lord, 25/9/2021 is liable to be struck down, being ultra vires of Article 14, 16, 21, 311(2), being violative of the Guwahati High Court rules. And these are my lord, submissions, my lord, subject to what my learned senior friend has to argue, my lord.
My lord, I take your lordship straight to my interlocutory application. Only 4 pages, my lord. Annexure 1, 2, and 3.
IA.
IA, my lord. ISC 2241 of 2020. Page number 9. Page 19, Annexure 1. Only 4 pages of this case, my lord. It is dated 21/2016.
Yes.
Office order with reference to their applications for the post of LDA and as per the recommendations of the selection committee in its meeting held on so and so and subsequent approval of the Honorable Vice Chancellor on so and so, following candidates are engaged as LDA in offices places as shown against their names as given below. My lord, the writ petitioner's name finds place at serial number 3. Next page. It is important. The terms and conditions of the appointment. Page 20. The engagement is subject to the following terms and conditions. 1. I'll refer only 1 and 4. The engagement is on purely temporary and on contractual basis, initially for a period of 1 year and may be terminated at any time. It is important. Page 20. It starts from page 19, my lord, that office order of 2006. The engagement is on purely temporary and on contractual basis, initially for a period of 1 year. Now it is important, my lord, and may be terminated at any time without assigning any reasons thereof. These 2 terms, my lord. Terminated at any time without assigning any reasons thereof. It has been interpreted in Kumari Sri Lekha by the Supreme Court. I'll refer later. This is clause number 1. Now we can skip the other clauses. Now clause 4. The engagement is subject to getting the character and antecedents to be verified from the police authorities. He has been arrested by police force. Now, kindly turn to next page, Milord. Annexure 2, page 21. His contextual period has been extended on numerous occasions. This is the last extension order. Office order dated 27/7/2021, Annexure 2, page 21.
This order dated
27/7/2021. Down below, Milord. Signature register Guwahati University dated 27/7/2021. Last extension order regarding writ petition. May I read? As per approval of the Honorable Vice Chancellor Guwahati University dated so and so, the term of engagement of following LDAs on contractual basis is hereby extended for another period of 6 months, with effect from the date as mentioned against their names. Serial number 3, Sasanko Soikia. Milord, kindly turn to that last column. Date of effect 1/7/2021. So it has been extended for 6 months. That means his service was up to 31st December 2021. And December 2021, he has been terminated in September 2021.
prior to the expiry of the.
Milord. Only 2.5 months were left, Milord, at that time. Whether it was feasible, practicable, I will refer to Tulsiram Patel and Kumari Srilekha later. They are required to submit their joining report to the undersigned with copies to the Treasurer Guwahati University. The other terms and conditions of his extension period of service will be same as earlier. Now the impugn termination notification. Next page. Page 22, Annexure 3. The termination order was issued 25/9/2021.
Yes.
May I read? This is notified for information of all concerned that the Chief Minister's Special Vigilance Cell has arrested Sri Sasanko Soikia and other 2 persons, Milord, Tridip Sharma and Babylon Kapoti, in connection with the APDCL recruitment test. In view of the above, the service of Sri Sasanko Soikia, LDA contractual, Office of the Secretary, University Classes, Guwahati University, has been terminated with immediate effect as per clause number 1 of the terms and conditions of his appointment order dated 21/2016. That Annexure 1. Terms and condition number 1. Terminated with immediate effect. Next parameter. Further, ITI Limited is hereby informed to terminate the service of Sri Tridip Sharma with immediate effect and make an alternative arrangement in place of him. Also, the security agency, that is Group 5 Placement and Security Services, is hereby informed to terminate Sri Babylon Kapoti with immediate effect. Moreover, the entry of the above 3 persons is restricted, not barred, Milord, is restricted inside the Guwahati University campus henceforth. These 3 persons' entry has been restricted, but he has been allowed to submit his representation, his appeal petition, and other things, Milord. But his entry, as well as other 2 persons, has been restricted, not barred. This is issued with the Honorable Vice Chancellor's approval dated so and so. Now, first, Milord, that Article 311(2). Constitution.
Yes.
It squarely falls under Article 311, exception 2. Article 311. Dismissal, the heading, dismissal, removal, or reduction in rank of persons employed in civil capacities under the union or a state. Now we can skip 1 or 2. no such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. Next, the proviso, my lord. Provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed. Now it is important. Next, provided. Provided further that this clause shall not apply. We can skip A. Now B. We can skip A and C. C is regarding president and governor's, my lord, satisfaction, and the first one is regarding conviction on criminal charge. Now our case falls under proviso B, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason. Lord, on the earlier occasion, I have pointed out that punctuation mark, comma, it is important, Lord, is satisfied that for some reason, comma, to be recorded by that authority in writing, again that punctuation, comma, for some reason, to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry. There must be some reason in existence that to be recorded by the authority in writing, whether it is in termination order or elsewhere, Miller, it is not clearly laid down in the proviso, Miller. That has been clarified in the constitutional judgment of Tulsiram Patel. I'll refer to that later. Now we can skip C. Now 311(3). If in respect of any such person as aforesaid, a question arises whether it is reasonably practicable to hold such inquiry as is referred to in clause 2, the decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final. The decision shall be final and the satisfaction of that authority empowered to dismiss or remove. Now, my lord, first, Kumari Sri Lekha, my lord. Justice J.S. Verma, R.M. Sahai. Etu loi jabo. 1991, 1 SCC, page 212. Kumari Sri Lekha, Vidyarthi and others versus State of UP and others. Is regarding Office of the Post of Government Advocate, Miller, District Government Council of the State of UP. Kindly turn to paragraph 13. 13. Termination of Government Advocate, Miller. But the ratio, it is clear from paragraph 13, Miller, regarding termination at any time without assigning any cause. Paragraph 13, Miller. May I read, Miller? The learned additional advocate general contended that clause so-and-so of so-and-so says that the appointment of a district government council is only professional engagement, terminable at will on either side and not appointment to a post under the government. And the government has the power to terminate the appointment at any time without assigning any cause. He contended that this power to terminate the appointment at any time without assigning any cause and the clear statement that the appointment is only professional engagement, terminable at will on either side is sufficient to indicate that the relationship is same as that of a private client and his counsel. In our opinion, this provision has to be read not in isolation, but in the context in which it appears and along with the connected provisions already referred to. The expression professional engagement is used therein to distinguish it from appointment to a post under the government in the strict sense. This, however, does not necessarily mean that a person who is not a government servant holding a post under the government does not hold any public office and the engagement is purely private with no public element attaching to it. This part of clause 3 of para so means only this and no more. The other part of clause 3, which enables the government to terminate the appointment at any time without assigning any cause, can also not be considered in the manner suggested by the learned additional advocate General. It is important. No. The expression at any time merely means that the termination may be made even during the subsistence of the term of appointment. His contextual period was up to 31 December. He has been terminated prior to that on 25 September 2021. Before 3 months, during the currency of the appointment, contextual period. During the termination may be made even during the subsistence of the term of appointment and without assigning any cause, means without communicating any cause to the appointee whose appointment is terminated. That is important, my lord. Without assigning any cause means without communicating any cause to the appointee whose appointment is terminated. However, without assigning any cause is not to be equated with without existence of any cause. The records will reveal, my lord. It merely means that the reason for which the termination is made need not to be assigned or communicated to the appointee. It was held in Liberty Oil Mills versus Union of India, Constitutional Bench Judgment, Miller, that the expression without assigning any reason implies that the decision has to be communicated, but reasons for the decision have not to be stated, but the reasons must exist otherwise. The decision would be arbitrary. The non-assigning of reasons or the non-communication thereof may be based on public policy, but termination of an appointment without the existence of any cogent reason in furtherance of the object for which the power is given would be arbitrary and therefore against public policy. My lord, the sum and substance of this paragraph 13 is that he may be the writ petitioner may be terminated during the currency of his contextual period without assigning any reason, but the reason must exist. That should not be communicated to him in the termination order. Now, the landmark judgment of Tulsiram Patel Miller, Constitutional Bench Judgment Miller. Several legal aspects have been dealt with, Miller. Clearly dealt with. Five judges Constitution Bench, Miller, headed by Y.V. Chandrasud, Chief Justice. Paragraph 126, Miller. Page 500, Miller.
Yes.
Down below, 125 and 126. We can directly go to the 126 para. May I read, Miller? Para 126. As pointed out earlier, the source of authority of a particular officer to act as a disciplinary authority and to dispense with the inquiry is derived from the service rules, while the source of his power to dispense with the disciplinary inquiry is derived from the second proviso to Article 311(2). There cannot be an exercise of a power unless such power exists in law. If such power does not exist in law, the purported exercise of it would be an exercise of a non-existent power and would be void. The exercise of a power is therefore always referable to the source of such power and must be considered in conjunction with it. The court's attention in Salappan case was not drawn to this settled position in law, and hence the error committed by it in considering Rule 14 of the Railway Servant Rules by itself and without taking into account the second proviso in Article 311(2). It is also well settled that where a source of power exists, the exercise of such power is referable only to that source and not to some other source under which where that power exercised, the exercise of such power would be invalid and without jurisdiction. Similarly, if a source of power exists by reading together two provisions, whether statutory or constitutional, and the order refers to only one of them, the validity of the order should be upheld by construing it as an order passed under both those provisions. Further, even the mention of a wrong provision or the omission to mention the provision which contains the source of power will not invalidate an order where the source of such power exists. It is important because the omission to mention in the impugned orders the relevant clause of the second proviso or the relevant service rule will not therefore have the effect of invalidating the orders, and the orders must be read as having been made under the applicable clause of the second proviso to Article 311(2), read with the relevant service rule. It may be mentioned that in none of the matters before us has it been contended that the disciplinary authority which passed the impugned order was not competent to do so. So, my lord, omission to mention
That
about
is a different thing. Omission to mention is a different thing.
my lord, in the termination order,
But to give the reasons,
my lord, I will go to the other paragraphs, my lord.
we'll rest after 5.
Lord, I have read paragraph 126. Now, paragraph 130. 130.
30.
130, page 503.
Yes.
Regarding reasonableness and practicability of dispensing with inquiry. Paragraph 130. The condition precedent for the application of clause B is the satisfaction of the disciplinary authority that it is not reasonably practicable to hold the inquiry contemplated by clause 2 of Article 311. What is pertinent to note is that the words used are not reasonably practicable and not, quote, Miller, impracticable. Not reasonable, practicable, and impracticable. According to the Oxford English Dictionary, practicable means capable of being put into practice, carried out in action, effected, accomplished, or done, feasible. Webster's Third New International Dictionary defines the word practicable inter alia as meaning possible to practice or perform, capable of being put into practice, done, or accomplished, feasible. Further, the words used are not practicable but not reasonably practicable. Webster's Third New International Dictionary defines the word reasonably as in a reasonable manner to a fairly sufficient extent. Thus, whether it was practicable to hold the inquiry or not must be judged in the context of whether it was reasonably practicable to do so. It is not a total or absolute impracticability which is required by clause B. What is requisite is that the holding of the inquiry is not practicable in the opinion of a reasonable man, taking a reasonable view of the prevailing situation. That we can skip other paragraphs similar. Now, paragraph 1 134 and 135.
Yes.
Page number 505. 134. A part of that paragraph has been, my lord, already read by my learned friend, my lord. Not the entire paragraph, my lord. The first 6-7 lines are most important in this case. Paragraph 134. It is obvious. It is regarding, my lord, recording of, my lord, reasons. These 4 or 5 lines, my lord. Very, very important, my lord. It is obvious that the recording in writing of the reason for dispensing with the inquiry must precede the order imposing the penalty. The reason for dispensing with the inquiry need not therefore find a place in the final order. Need not find a place in the final order. That means the termination order. It would be usual to record the reason separately, and then consider the question of the penalty to be imposed and pass the order imposing the penalty. It would, however, be better to record. It would, however, be better to record the reason in the final order in order to avoid the allegation that the reason was not recorded in writing before passing the final order, but was subsequently fabricated. The reason for dispensing with the inquiry need not contain detailed particulars, but the reason must not be vague or just a repetition of the language of clause B of the second proviso. For instance, it would be no compliance with the requirement of clause B for the disciplinary authority simply to state that he was satisfied that it was not reasonably practicable to hold any inquiry. Sometimes a situation may be such that it is not reasonably practicable to give detailed reasons for dispensing with the inquiry. This would not, however, per se invalidate the order. Each case must be judged on its own merits and in the light of its own facts and circumstances. Next parameter, 135. It was vehemently contended that if reasons are not recorded in the final order, it is very much relevant, my lord. If reasons are not recorded in the final order, they must be communicated to the concerned government servant to enable him to challenge the validity of the reasons in a departmental appeal or before a court of law, and that failure to communicate the reasons would invalidate the order. That was the argument, my lord. Now, the court's, my lord, opinion. This contention too cannot be accepted. That contention has not been accepted by the Supreme Court. This contention too cannot be accepted. The constitutional requirement in clause B is that the reason for dispensing with the inquiries should be recorded in writing. There is no obligation to communicate the reason to the government servant. As clause 3 of Article 311 makes the decision of the disciplinary authority on this point final, the question cannot be agitated in a departmental appeal, revision, or review. The obligation to record the reason in writing is provided in clause B so that the superiors of the disciplinary authority may be able to judge whether such authority had exercised its power under clause B properly or not, with a view to judge the performance and capacity of that officer for the purposes of promotion, etc. It would, however, be better for the disciplinary authority to communicate to the government servant its reason for dispensing with the inquiry, because such communication would eliminate the possibility of an allegation being made that the reasons have been subsequently fabricated. It would also enable the government servant to approach the High Court under Article 226 or, in a fit case, this court under Article 32. If the reasons are not communicated to the government servant and the matter comes to the court can direct the reasons to be produced and furnished to the government servant, and if still not produced, a presumption should be drawn that the reasons were not recorded in writing and the impugned order would then stand invalidated. Such presumption can, however, be rebutted by a satisfactory explanation for the non-production of written reasons. So, my lord, the non-mentioning of the reasons in the final termination order would not invalidate that order. But it would be better, that word has been used by the Honorable Apex Court, my lord. It would be better if the reasons are recorded in the termination order itself. But it does not mean that the entire termination order would be invalidated if the reasons are not recorded in the termination order. But the existence of those reasons must be there in the records. And I will produce the records. The reasons are there. So this celebrated case of Tulsiram Patel, Miller, it is clear that non-mentioning of Article 311(2) won't invalidate. It is not impracticable, but reasonably not practicable to hold the inquiry. That would be enough. And the most vital thing, that reasons to be recorded in writing, it won't invalidate that termination order. And another thing, paragraph 138 is also important. Paragraph 138, 507. It goes to the arena of administrative discretion.
Yes.
Paragraph 138, page 507. Paragraph 138.
Yes.
Where a government servant is dismissed, removed, or reduced in rank by applying clause B or an analogous provision of the service rules, and he approaches either the High Court under Article 226 or this court under Article 32, the court will interfere on grounds well established in law for the exercise of power of judicial review in matters where administrative discretion is exercised. It will consider whether clause B or an analogous provisions in the service rules was properly applied or not. The finality given by clause 3 of Article 311 to the disciplinary authority's decision that it was not reasonably practicable to hold the inquiry is not binding upon the court. The court will also examine the charge of malafide, if any, made in the writ petition. In examining the relevancy of the reasons, the court will consider the situation which, according to the disciplinary authority, made it come to the conclusion that it was not reasonably practicable to hold the inquiry. If the court finds that the reasons are irrelevant, then the recording of its satisfaction by the disciplinary authority would be an abuse of power conferred upon it by clause B and would take the case out of the purview of that clause, and the impugned order of penalty would stand invalidated. In considering the relevancy of the reasons given by the disciplinary authority, it is important, my lord. In considering the relevancy of the reasons given by the disciplinary authority, the court will not, however, sit in judgment over them like a court of first appeal. In order to decide whether the reasons are germane to the clause B, the court must put itself in the place of the disciplinary authority and consider what, in the then prevailing situation, a reasonable man acting in a reasonable way would have done. The matter will have to be judged in the light of the then prevailing situation and not as if the disciplinary authority was deciding the question whether the inquiry should be dispensed with or not in the cool and detached atmosphere of a courtroom, removed in time from the situation in question. Where two views are possible, the court will decline to interfere. It is important, my lord. When two views are possible, the court will decline to interfere. My lord, regarding that two views, my lord, I will refer Central School Service Commission case, my lord. West Bengal Central School Service Commission and others. Only regarding that two views, it will be
The citation document.
yes. 2019, volume 18, SCC, page 39. It starts from paragraph 30, my lord, 32, my lord, 31 and 32, my lord. I'll read from paragraph 30, my lord. 30, last but one page, my lord, page 45. Particularly centering around that two views, my lord. Paragraph 30. In exercise of its power of judicial review, the court is to see whether the decision impugned is vitiated by an apparent error of law. The test to determine whether a decision is vitiated by error apparent on the face of the record is whether the error is self-evident on the face of the record or whether the error requires examination or argument to establish it. If an error has to be established by a process of reasoning on points where there may be reasonably be two opinions, it cannot be said to be an error on the face of the record, as held by this court in Satyanarayan Lakshminarayan Hegre versus so-and-so in 1960. If the provision of a statutory rule is reasonably capable of two or more constructions, and one construction has been adopted, the decision would not be open to interfere by the writ court. It is only an obvious misinterpretation of a relevant statutory provision, or ignorance or disregard thereof, or a decision founded on reasons which are clearly wrong in law, which can be corrected by the writ court by issuance of a writ of certiorari. Para 31, next paragraph. The sweep of power under Article 226 may be wide enough to quash unreasonable orders. If a decision is so arbitrary and capricious that no reasonable person could have ever arrived at it, the same is liable to be struck down by a writ court. If the decision cannot rationally be supported by the materials on record, the same may be regarded as perverse. Now, paragraph 32, my lord. It is important, my lord. However, the power of the court to examine the reasonableness of an order of the authorities does not enable the court to look into the sufficiency of the grounds in support of a decision to examine the merits of the decision, sitting as if in appeal over the decision. The test is not what the court considers reasonable or unreasonable, but a decision which the court thinks that no reasonable person could have taken, which has led to manifest injustice. The writ court does not interfere because a decision is not perfect. So, my lord, if there are two views, then, my lord, the court won't interfere. And if it is perverse, my lord, arbitrary, against the statute, my lord, then definitely the court will interfere. Now, my lord, some cases, my lord, inquiry not necessary for temporary employee, my lord. I'll skip those judgments, my lord, and notice served under section 27 of General Clauses Act, my lord. So not so relevant. Communication of order, my lord. And my lord, regarding that useless formality, my lord, and equity, there are so many cases, my lord. My lord, the stand of the university is, my lord, loud and clear. Inquiry, my lord, would not be, my lord, initiated, not reasonably practicable.
Why?
My lord, to initiate an inquiry against the writ petitioner, my lord, while, my lord, issuing that termination order. My lord, it squarely falls under Article 311 to, my lord, provision B. And satisfaction,
What was the reason recorded?
my lord,
What reason was recorded?
my lord, the records will reveal, my lord, the reasons, the background reasons, the existence of reasons as referred in the Procedural Petal case, my lord. Is helpful. How about it? That is the crux of the matter, my lord. Vital part, my lord. If there is no reason, my lord,
Have you flagged it?
Relevant portion to flag
Miller?
for assembly.
my lord, that it was very to build an like smart location. Reform here. মানে এই পেজটো আৰু as per Tulsiram Petal, my lord, if these reasons are relevant, my lord, then the termination order will stand. If these reasons are not relevant, irrelevant, then termination order will go. I have gone through the reasons, my lord, and I find it relevant, my lord.
Yes. And what are the other records?
My lord, it is only regarding the termination order and the connected, my lord, existence of reasons, my lord.
Any other records here?
No, my lord, I don't have any other records.
What
On the last occasion, your lordship, my lord, asked whether there are any reasons, my lord. So, my lord, this file contains the reasons, my lord. If the reasons are relevant, my lord, then matter ends there. And if irrelevant, then, my lord, termination order will go. Very simple at that. Applying to Tulsiram Petal, that consideration based. Paragraph 134 and 135. It would be better if the termination order contains the reason. But non-mentioning of the reasons won't invalidate the termination order. That is the, my lord, sum and substance of paragraph 134 and 1. That's my humble opinion.
My learned senior friend had referred to
Oh,
my.
one more thing, on the restriction for the entry into the Guwahati High Court, there's one ground that he has taken.
Stigma.
His word is that he has been barred, not barred, restricted.
Restricted.
Since it's a sanctity of entire examination system. So, my lord, that discretion, my lord, at least the administration may, my lord, exercise.
Was a decision taken to that effect also?
My lord.
was a decision taken to restrict them from entering into the Guwahati University?
Milord, that order reflects, Milord, but in the notings of the file, Milord, possibly there is some indication, Milord. I
Just
don't
check
know.
up. There has to be some reasons.
He has submitted, in spite of that restriction, he has submitted his representation. Twice
Two
or
others,
thrice, Milord.
to some colleagues, because I was not allowed. And there was an interim order after that.
Maybe it will take some time for you to go through.
Milord,
We'll fix another day.
My lord. But just to counter two
You
points,
counter on the other day.
Milord.
because
Make a small written submission also.
I'll make. But
Both of
just one thing of Tulsiram,
Written arguments.
my lord. One thing of Tulsiram, which my learned senior friend had very rightly fully pointed out, he had pointed out that it would, however, be better for the disciplinary authority to communicate to the government servant its reason for dispensing with the inquiry, because such communication would eliminate the possibility of any allegation being made that the reasons have been subsequently fabricated. Now, it says, my lord, if the it would also enable the government servant to approach the High Court under 226. If the reasons are not communicated to the government servant and the matter comes to the court can direct the reasons to be produced and furnished to the government servant. And if still not produced, a presumption should be drawn that reasons were not recorded in writing. So, my only humble submission is, as held by Tulsiram itself, I have approached this honorable court, my lord. I would like to, my lord, have a look at the records so as to
That particular page.
exactly
That particular page.
that particular.
Where the reasons are recorded.
Otherwise, how will I counter, my lord?
You can show it to him.
Yes.
Not all the records. Only
Not
that
all the
particular
that
page.
particular page, reasons to be recorded in writing.
Where the reasons have been recorded. You can show it to him.
Only then my lord, I'll be able to counter whether it is relevant or adequate.
Also heard Mr. Williams.
No problem, no, no.
Guwahati University. 13 part. List for further hearing again. On when do you want?
Milord,
My lord, they can have it on, my lord.
Let's take a short date so that
Or that,
we can.
otherwise, flow is broken, my lord. Either on 2nd or on 7th.
Milord,
7th is a holiday.
Oh, 7th. 9th.
can it be on Milord?
If long date, my lord.
16.
বহুত লম্বা হয়ে যাবে মানে ফ্লোটো ভাঙি যায়
On 16, Milord, Thursday.
On 16th.
16th.
That day you can bring your written argument.
my lord, as a part head matter, it comes.
Yeah, as part.
And then I will be allowed to see that portion of the recording.
Milord, just now I'll show him.
I'm deeply obliged to your lordship, man, for the patient hearing, man. Obliged. Most obliged.
Thirteen.
Lordship, 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 the petitioner joined as a graduate engineer, my lord, in the year 1997, and thereafter his services were confirmed, and thereafter he was posted as project engineer, my lord. However, my lord, he was on probation, my lord, in the till the year 1999. Thereafter, my lord, the petitioner was promoted as grade B assistant manager NRL, my lord. In this petition, my lord, we are praying for promotion of the petitioner, my lord.
No, you place your facts first.
Yes, my lord.
If you're not ready, we'll take up some other day. If
Uh,
you're ready, we'll
Lordship,
take up.
can it be after some times, my lord? After some times, my lord.
After some, why after some time?
Lordship, my senior would like to please, my lord.
Who's your senior?
Miss B. Bhuya would like to please, my lord. After some time, my lord.
Or some other day inconvenient for our senior.
On another date, madam.
When? After a week?
After a week, madam.
On request made on behalf of my senior.
Lordship is fixing any date?
No. This October.
I'm authorized.
14.
This is a case of non-consideration of promotion from Inspector Food and Civil Supplies to Superintendent of Food and Civil Supplies. While making the promotion of the private
1 minute. Yes. How many respondents are here? You are appearing, Chakravarti?
Lordship, I am appearing respondent number. One.
7 respondents.
7 respondent, I am appearing 1, 2, 3. Lordship.
4 APSC?
4 appeals.
You are appearing.
My friend.
And 5, 6, 7?
I'm appearing for respondent number 7.
7. Yeah.
My lord, petitioner is superseded by the private respondents, my lord. Petitioner is senior in the gradation list and those private respondents are junior to the petitioner in the gradation list. Lordship, may kindly peruse the gradation list at page 20, my lord.
20.
Page 20, name of the petitioner reflected in serial number 36, my lord.
Yes.
And name of the others are 39, 54 and 72.
39.
39, 54 and
This is
72.
respondent.
Respondent number 5, 6 and 7, my lord.
39 is respondent number.
39 is respondent number. Just a minute. 39 is Ranjit Kumar Bhattacharya, respondent number 5, my lord. Then 54, my lord. 6, my lord. 54 is Mr. Ojit Kutum. He is respondent number 6, my lord. His position at serial number 54, my lord. And the 7 is Akhilesh Das. He is at 72, my lord. At space 22, my lord.
Yes. 1 minute. Yeah. Yes.
My case is that according to the service rule, my lord. According to the service rule.
Where's the service rule?
It is, I have a copy of the service rule, my lord. I am just submitting before your lordship, man. In every case where a junior member in the cadre is selected in preference to his senior, In that cadre, the committee shall record in writing the reason of such supersessions.
So committee was constituted
Committee was constituted, they have filed an affidavit, my lord.
DPC.
DPC. I have
Where's the
another
DPC?
fact is important, my lord. Another fact is important. Subsequently, another DPC meeting was held. In that DPC meeting, the case of the petitioner was considered. And it is stated in the DPC meeting that some departmental proceeding has been pending against him. Upon exoneration of that departmental proceeding, his case was considered by the next DPC and give him a promotion from 7/11/2020 instead of the date of the earlier promotion, that is
Where's the promotion order?
the promotion order achievement periods at page 46.
No. Promotion of your juniors. The first
Promotion of the
promotion
improved order, my lord, that's page 28, my lord. Relevant portion is page 29, my lord. This 19, 20, and 21, Ranjit Bhattacharya, Ajit Kumar, Ajit Kutum, and Alakesh Das. These 5, 6, and 7 respondent number were promoted in supersession of the petitioner, my lord, who is senior, my lord, without recording any reasons of supersession, my lord.
Yes.
Subsequently, he was promoted from another date, my lord. Although it was retrospective, with not effect from that date, my lord.
Where's that order?
That is order at page 46, my lord. See,
Page?
page 46, running, my lord, running page.
Yes.
Lordship may see on 19 August 2021, Mr. Robindra Deka at serial number 1 as Superintendent Food and Civil Supplies and posted as Deputy Director of Food and Civil Supplies, Baksa, my lord. Other allowances admissible as per route retrospective to 7/11/2020, whereas the respondent number 567 was promoted from 7/3/2019, my lord. This is the simple case, my lord. They have filed an affidavit, my lord.
Are you challenging this order?
I have challenged this order, my lord.
Your promotion order?
Their promotion order.
Your promotion order?
My promotion order is not under challenge. I am just wanting, my prayer is to give a retrospective effect along with my juniors. They have filed an affidavit, my lord, stating that my Lordship may kindly see their affidavit, my lord, at para 9.
Page?
Page 33, as they mentioned, my lord.
Page. This is an additional affidavit.
No, that is the pagination is probably wrong, my lord.
33, Lordship.
No, it is not 33. It is not 33. They wrongly. It will be after 46, my lord.
Yes. Paragraph?
Paragraph 9.
9 of them.
9, my lord. 4th line, my lord. Paragraph 9, 4th line. Due to inadequate ACR in respect of the petitioner at the time of meeting of the Departmental Selection Commission dated 26/2/2019. However, the DP drawn against the petitioner is not nominal till that holding the meeting of the department selection. It is not a ground by at all. Not having the ACRs. He is not promoted. At the time of departmental promotion committee meeting, his ACRs was not made available. That is why his promotion was not considered by the departmental promotion committee. However, the subsequent DPC kept the recommendation under a seal cover, my lord. You are subsequently open and given effect to, my lord. I have filed a reply, my lord, in which the in para 50, page 57, lordship, running page, my lord, the minutes of the meeting, lordship may kindly see page 57, minutes of the meeting of the departmental promotion committee held on 26/2/2019, my lord. Lordship may kindly come to the page 59. Last paragraph. Lordship got it? The departmental selection committee decided not to recommend the remaining officers in the rank of inspector.
1 minute, where is this? Last para?
Last page, my lord, page 59, my lord. Running page 59.
Page 60.
No, 59, my lord.
59 is ending with this.
Here it is 59, my lord. 59, then the earlier page, my lord.
Anyway, what, read it.
The departmental selection committee decided not to recommend the remaining officers in the rank of inspector under the zone of consideration promotion to the post of superintendent due to unavailability of required ACRs and APRs. No, there is the subsequent DPC has not referred to the anything about the earlier
Where's the
DPC.
subsequent, how many DPCs were there?
Lordship, on earlier, it was 2 occasions, Lordship, DPC was held, Lordship. On
One.
held on 26/2/19, Lordship.
Oh, that
And
was the
another DPC was held in 7/11/2020, Lordship. And subsequently, he was promoted, Lordship. With retrospective effect, Lordship.
No, what was the ground for not considering his case?
Lordship, due to non-availability of ACR's, Lordship, and departmental proceeding was pending that time, Lordship. He was not exonerated.
If the departmental is proceeding is pending against the particular person, during the course of consideration, my lord, that has to be kept under the seal cover, my lord. That has not been banned by the departmental promotion.
No.
Kept in seal cover, Lordship.
The subsequent DPC kept under the seal cover.
It was
was
kept
kept
under
I am
the-
concerned on the 26/2, my lord.
Hmm?
I am concerned of the meeting of the departmental proceeding in which my case ought to have been considered, my lord. Where my case has not been considered for want of ACRs, my lord. On 26/2/2019, my case has ought to be considered, my lord. That was not considered, my lord, without giving any reasons whatsoever, my lord. Subsequent DPC has considered my case and give me a promotion from a later date, my lord.
That we've got it.
Is further promoted, Lordship, Assistant Director of Food and Civil Supply, Lordship. Subsequently, Lordship is promoted to the post of Assistant Director.
Where's the DPC minutes of
It was in the record, Lordship.
Be sure to do the
8/10/2020?
flag law.
26/2/19.
এইখন মই দিছো আপুনি পিছৰখন দিয়ক পিছৰখন দিয়ক
No, this is 26 to 2019. I'm asking 18/2020.
Eight, 10, one, 8, 10.
Not this. You produce the DBC minutes.
Eight, 8, 10. Nine. Like the one.
Okay, take down. What, Mr.
DN Bhattacharya.
Ian Bhattacharya, Learning Council for the Petition. Mr. Chakravarti, Learning Government, shall produce a copy of the DBC minutes dated 8/10/2020. When do you want?
Next week,
Next week.
next, after election.
No, my lord, it is, I am retiring, my lord.
No.
On 16, Lord, 16 May.
16 May is
16
too
May.
long, my lord.
16th of.
16 May. He must be required. Lordship, my lord, keeping the matter part heart,
No.
it will go another bench, my lord.
Doesn't matter.
15.
My lordship, my senior legs in the other court. Please kindly pass over the matter for timing.
Otherwise, it's a matter ready for disposal.
Seventeen.
Okay, before starting by my senior, by my friend, Lordship. In this case, Lordship, we APS is supposed to file an affidavit. So the affidavit is ready. We need to file only 3 days time to file, Lordship.
Otherwise, my lord, I have submitted on the last occasion. It is a covered case by a judgment passed by a coordinate bench, my lord, and the issues that I'm raising has been squarely covered by the judgment of the coordinate bench of this honorable court, my lord.
Okay, let him file.
Let him file, my lord. I have no objection to that.
But
Kindly,
Mr. H. Bora Gohind, Learning Council for the Petition. Mr.
PP Doctor.
PP Dutta, Learned.
Council response, representing 4, 5, 6, and 7 APS.
Learned Council appearing for the respondents 4 to 7. Submits the affidavit is ready. And the same shall be filed within a period of 1 week.
1 week.
1 week. Prayers allowed, release up to 1 week.
my lord, we have an interim protection continuing. Kindly,
Interim order passed ready to continue.
Ma'am, there is a similar matter, if your lordship may allow, my lord. Item number 28 is the same issue, my lord. We are ventilating before your lordship, my lord. There also, if my learned friend takes the similar instructions, my lord.
Yes, Lordship.
Here also interim is there.
Yes, my lord. In both the cases, we have interim orders, my lord.
Here also you are appearing for respondents.
Yes.
Same respondent, my
Same
lord.
respondent.
Same order.
Same.
28, my lord.
Same order.
I'm highly obliged, my lord. Deeply.
18.
Lordship, here I am supposed to file affidavit on behalf of the Higher Education Department, Lordship. The records are with us, Lordship, and that is why, Lordship, the department is facing trouble to place us the instruction, Lordship. So, Lordship, 2 weeks time may be granted, Lordship, we will return the records so that they are able to give us the pairwise form. We'll file an affidavit accordingly.
My lord, in this case, my lord, what happened, we have challenged the appointment and selection of the private respondent. But incidentally, what happened, private respondent has gone to another college. So now in the select list,
selectee number 2 and 3, they are also fighting for some other colleges. So I am the fourth one, but I did not implement second and third in order to know their position before this honorable court. If they say they have given their right, then only I may come into the picture. So if Lordship allows, then I'll implement them and file an amended petition, my lord.
Because they still may be interested.
They still may be interested. To my knowledge, they are not interested, but they have to tell this honorable court.
Okay, Mr. J. Abidin, then the counsel for the petition. Praise for how much time?
My lord, 1 week time.
1 week time to file an appropriate application for improvement of necessary parties, correct? Praise the Lord, list up to 1 week.
Lordship, may record our presence.
Mr.
HMO for respondent number 3.
HMO, then the counsel appears for respondent number 3.
I am appearing for respondent number 1 and 2.
Mr. Upadhyay.
P. Upamanian.
P. Upamanian. Then standing counsel?
Higher education.
Higher education appears for 1 and 2, and Mr. M. Sharma for the respondent number 7.
My lord, instead of 1 week, it could be 2 weeks, ma'am.
Okay, make it 2 weeks, wait for 2 weeks time. Praise on this of the 2 weeks.
19.
Deeply obliged, ma'am.
Your Lordship, matter relates to compassionate appointment, Your Lordship. On last occasion, Your Lordship has directed the SD to file detailed affidavit, Your Lordship.
Lordship, received, Lordship. In the instruction, Lordship, it is stated that in 2009, Lordship, there is no scheme for a retirement under the compassionate appointment, Lordship, or for the being a voluntary retirement, Lordship. That is the instruction, Lordship.
Let them file affidavit, Your Lordship.
File
affidavit, Lordship.
Mr. K. Mera, then the counsel for the petition. Mr. H. Agawati, then government is allowed. How much time?
2 weeks, Lordship.
2 weeks time.
Also, Your Lordship, his case was placed before the DLC in the meeting dated 14/6/2010.
DLC is not considered.
That DLC minors may be produced, Your Lordship.
No, DLC not considered, Lordship.
Okay.
That minors may be produced.
You produce the DLC, Lordship.
Obliged.
20.
Your Lordship, after some time, Your Lordship. Much obliged.
21.
After some time?
Lordship, otherwise pleadings are complete, Lordship. Lordship can be fixed, the matter can be fixed for hearing.
Lordship, after some time, I don't have instruction as regards, Your Lordship. Much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Neither the petitioner, Lordship, he was appointed in the year 2004, my lord, as a work charge worker, my lord, under the Department of Panchayat Rural Development Department, my lord. What happened, my
You
lord?
filed your affidavit.
My lord, in this case, my lord, at present stage, my lord, affidavit is not required. What happened is that Upen Datu's judgment was passed in the year 2017. After that, the department had furnished a list of 1,080 casual workers, including the petitioner, who was found eligible to receive the minimum of pay scale. That list was, my lord, forwarded to the finance department for their approval. So, my lord, their approval till date has not been forthcoming. So,
The
finance
finance
department,
party,
Yes, my lord.
they will
who
be now.
appears for finance?
But my lord, some juniors of the petitioner, my lord, they were appointed.
So
my
that's why let us see what the finance says.
lord. Yes.
Until the approval comes,
You've given the proposal, isn't it?
we have given all their particulars to the department. A copy also of the.
Who appears for finance? H. Holder Finance. Who was appearing last time? H. Alia. So according to you, how much? 1,000?
1,080 a list of 1,080 casual workers, my lord, which included the name of the petitioner as well, was forwarded to the finance department for their approval. Their approval is still pending as. So I don't have the instructions that aspect.
Whether the finance has given the approval.
That we have not received it.
Where's the proposal?
I have it with me, the records.
They may furnish a copy, my lord.
First paragraph. First paragraph of the instruction. And this one as well. Hey, Dada, it would idiot. Photo mic. Sound.
Sit at two. You take it back. But Chalia, you have come,
Yes, Lordship. Lordship, here what has happened was, Lordship, I have sent this, but Lordship, there was actually the copy which I had received, there was one typographical mistake, my lords. Here the name was written as Tajuddin, my lords, whereas the actual petitioner's name was Tajuddin. So there was some confusion in the finance department regarding any up-to-date instruction has been placed, my lord, because so.
according to the standing council, Panchayat department, a list of 1,080 casual employees.
Yes, Lordship.
Was sent to the finance
For,
where the name of the petitioner is also included
yes, Lordship.
for granting minimum scale of pay.
Yes, and that has.
That is still pending before you.
Lordship, that is what Lordship here, Lordship, I'll seek some accommodation because there was some because the petition here.
Okay,
So
third, Mr.
2
J.
weeks time.
Laskar, Leonard Council for the petition. B. Hentic. Leonard Council appearing on behalf of Mr.
K. Kumar,
K. Kunwar, Leonard Standing Council,
AG, additionally.
Leonard Additional AG submits that the Panchayat and Rural Development Department by letter dated, by proposal dated 17/11/2021 has furnished a list of 1080 casual workers under Panchayat and Rural Development Department for necessary concurrence towards grant of minimum of pay scale. Stop. And the name of the petitioner is included in the set list at serial number 320. Stop. However, it is submitted that the concurrence of the finance department is awaited till date. So, para Mr. A. Chalia, the Standing Council Finance Department. Praise for
Lordship, 2 weeks time, Lordship.
2 weeks time to enable him to receive instructions. Praise allowed, list up to 2 weeks. You take it back.
Any date variations, my lord?
No, I'm not fixing that. If I fix that, only some few cases will be in the service,
Lordship, this is the second round repetition, my lord.
whatever it is.
Lordship will expedite it.
All right.
Found suitable for promotion will be ranked in order of merit, depending on the grade where they are promoted. Percentage norms affixed as above, and shall decide number of executives to be promoted in the next higher grade. Where aggregate mark is same, they will be ranked in order of seniority. Then performance appraisal report. Performance appraisal report shall constitute 60 marks in all. The appraisal system will be on a 5-point scale, that is outstanding, very good, good, average, and poor. Each of these ratings have been defined in the formats, etc., etc. Yeah. Then my lord will kindly come to page 80.
80.
80. The DPC 11.5 just below that. DPC will award up to a maximum 15 marks to each eligible executive for interview in terms of subpara 10.5, keeping in view the relevant factors defined there. Then 81, my lord. The DPC shall award a total of 10 marks for field exposure as under. That means, my lord,
Page 81.
page 81, my lord, on top,
Oh, okay.
locational weightage, maximum marks 10. DPC shall award a total of 10 marks for field exposure as under. Now, there are 5 to 6 respondents who have been given promotion, my lord. For the last 21 to 20 years, they have not served anywhere other than the head office. They have also been promoted. And they admit, we filed an application under RTI, they admit, yes, they do not have field exposure. Then my lord will kindly come to page 84. .9. Please come to the chart, my lord. 2. For promotion to the grade of 6, minimum 4 years of experience at the level of 2 to 5, that is field exposure. That means one need to have minimum 4 years of field exposure, means posting, my lord, in the field, in the projects. Now, my lord will kindly come to page number 94. Before that, sorry, my lord, please come to page 86. This is part of that modified promotion policy. If your lordships will kindly come to the last column, minimum qualifying marks. Kindly see, for general it is 8 out of 15. And for SC/ST it is 7. Then my lord will kindly come to page number 94. The below mentioned managers in the scale of pay of rupees so and so are hereby promoted to the post of senior manager in the scale of pay of so and so with effect from 1/4/22. So our name, my name does not figure, my lord. So, for example, serial number 1 is R16, serial number 2 is R17, serial number 3 is R12, serial number 4 is R8, serial number 5 is R13, serial number 6 is R11, and serial number 7 is R5. Then at page 96, my lord. So, my lord, these are the orders. Now, let me formulate my points, my lord. So, basically, what we are challenging is, my lord, just to give a brief idea of what is my nature of challenge. My nature of challenge is twofold. Basically, my lord, the interview board has not followed the promotion policy in awarding marks for the interview. And secondly, my lord, respondents number 5, oh sorry, there's one more thing. The petitioner was not given the marks for acquiring, my lord, postgraduate diploma in engineering management in terms of the clause which I've already read out, which I'll come to it little late, my lord.
Postgraduate diploma.
Yes, postgraduate diploma in energy management. As per the promotion policy, I am entitled to some marks. That was not given to me. And most importantly, my lord, respondents number 5, 6, 7, 8, 9, and 12. They did not have a requisite field exposure of 4 years, and yet they have been promoted. Now, my lord, to bring home my point that the interview board committed a mistake, my lord, in assessing my merit in the interview, let me place my case. Now, I have already shown from my lord, please come to page 57 once. (10.6). The DPC shall interview executives in the grade of E6 and above with a view to ascertain their suitability for the next higher position. Marks for interviews shall be awarded by the DPC, taking into consideration factors like so and so, so and so, so and so. So, while the interview board members, my lord, while awarding marks, will keep in mind these 12 components which are indicated here. Read with this, yes. If your lordship would kindly come to page 77. The DPC shall interview executives in grade E2 and above and up to E6 with a view to ascertain their suitability for the next higher position. Marks for interview shall be awarded by DPC, taking into consideration factors like so and so, so and so, so and so. My lord, on subjective satisfaction, you cannot give me 6 or 8 or 10 or 12 out of 15. There are objective criteria. Those criteria you are required to take into account. Now, on these criteria, my lord, my ACRs are already there, where I have got, my lord, higher gradings. So, where is the scope to give me 6? It can't be. I know you are an expert. DPC is an expert, but your actions must be consistent with the promotion policy. Now, kindly see my lord, DPC, ACRs. Yes. সেই এছিয়াৰ বিলাক ক'ত আছিলে?
107 ৰ পৰা আৰম্ভ।
নহয়, ষ্টেটমেণ্ট এভাৰমেণ্টটো। এভাৰমেণ্টটো।
Paragraph 17, page 17C.
Yes.
Page 23-24.
Yes. দুটা paragraph. My lord will kindly come to page 23.
17C.
Page 23C, that's para 17C. That at least 10 out of 12 different aspects appearing in clause 10.5 of the promotion policy and the rules for NHPC executives amended on 29/1/22 can be related to the marks taken into consideration against different categories under 4 different heads. That is key performance area 75 marks, competency 15 marks, value 5 marks, and potential 5 marks, as well as comments in the attribute, integrity, and remarks in awarding final marks in PAR of the incumbent. The details of those categories are as under. Consistency in performance, whole attribute of key performance area, professional knowledge, serial number 2 under competency, ability to reason out logically, serial number 5 under competency systematic thinking, presentation of the ideas coherently, whole attributes of potential, environmental awareness, serial number 1 under competency, leadership potential for decision making, serial number so and so, communication skills, serial number 5 under potential, communicate ideas and information effectively, and market key points through public speaking and presentation, ability to convert ideas to action plan and ensure acceptability with the organization and performance at board meetings, sense of involvement, whole attribute of value, commitment to the organization, whole attributes of integrity, warning, etc., etc. Now please come to page 25. That the DPC can award a maximum of 15 marks in the interview, and while doing so, 12 aspects referred to in clause 10.5 is to be considered. In absence of any specific question discussion with regard to 12 aspects, the petitioner was under bona fide impression that DPC took into consideration the marks secured by the petitioner in PAR against at least the above referred 10 aspects. 2 other aspects, educational qualification and recognition appreciation letter of director, etc., were to be assessed based upon records available against the petitioner. The petitioner had consistently secured higher marks against 10 aspects as referred to earlier from PAR since the last 5 years. But in the interview, the 12 factors were not assessed individually, and marks awarded to the petitioner against those factors individually are not discernible from the annex appended to RTA reply dated 26/4/22. It is not clear as to on what basis DPC awarded 6, failing disqualifying mark out of 15 in favor of the petitioner in the interview. There were 7 members in the DPC, and any person with the minimum common sense would judicially think and award more than 6 out of 15 in case of an incumbent who have secured 56 out of 60 in the marks awarded for the last 5 years. But not a person who gets 56 out of 60, considering the same attributes. Now DPC is giving me 6. But it can't be that ipsi dixit. You'll have to show. Their affidavit does not reveal anything, my lord. Until and unless something is very bad had transpired in the interview, which of course is to be recorded in writing by the members. That in the absence of specific question, discussion involving each of the 12 aspects as required to be considered in terms of clause so-and-so of the executive amended by the so-and-so by DPC in respect of the petitioner, it could not have taken a completely adverse view against the petitioner in respect of those 12 aspects, which was in direct conflict with the marks awarded in petitioner's PAR for the year 2016-17, 17-18, 18-19, 19-20, and 20-21 against the attributes referred to in paragraph so-and-so. As such, DPC has acted in violation of clause 10.5 of the promotion policy and rules of the so-and-so. So this is our case. Now it is our specific case. Concerning those attributes, it's not that any question was posed to us, either by the 7 members of the interview board. So in the absence of any question having been posed or put, am I not to be under the impression that these aspects are already dealt with in my PAR, and where I have got 56 out of 60? And should I get 6 out of 15? This is our case, my lord. Basically, this is our case. And secondly, as I have already said, 5, 6, 7, 8, 9, and 12, they do not have any field experience and they admit it, my lord. Now, let me place my pleadings on the other point. If your lordships would kindly come to page 30. A conjoint reading of the aforesaid provisions makes it clear that for consideration for promotion to grade E6, a minimum of 4-year field exposure is essential. In the present case, respondent number 5, 6, 7, 8, 9, and 12 did not have the requisite field exposure of 4 years, and they were all required to be posted at places where there is field work to gain field exposure in strict conformity with the clause 19. Supposing, my lord, these people are only preparing, DPRs, but they must go to the site. How a dam is constructed, how this is done. So this is required because you'll become a senior manager. And that's the prescription. But they have not done. Now, when we filed a RTI reply, my lord, they give it. At page 105, my lord. Only difficulty is, my lord, the answers are in Hindi. I can't read Hindi. Hindi is not my language, my lord. I'm very sorry. 16, page 105. Number of candidates promoted to the post of SM, senior manager, who did not meet a requirement prescribed in clause 12.92 of the part 1 of his order number so and so. They say 5. The rest I don't know, my lord.
Same here. Can't you get something translated?
I think Adhikari, I think my learned friend is there. He can read it. Adhikari ka ki, I don't make any attempt also. I'll not. It's not my national language. I know English, I know Assamese, that's all. I can speak Hindi, I can't read. Because in school I read, my lord, ye kiya hai, ye talab hai. Beyond that, I have not read anything. We had a Hindi paper until class 6. Beyond that, we didn't have. Yes, they say 5. He, girl. I think, my lord, it could read like this, subject to correction. Information relating to marks secured by the petitioner was supplied to the petitioner, but information regarding promotees did not furnish. However, at serial 16 of the said reply, it was stated that 5 promotees have been promoted in terms of so and so, requirement of field exposure of 4 years. Ki holo? Eta kono নাই বলে তো কোট কলা
number of candidates promoted to the
the question was very specific.
Did not meet 1,000.
Did not meet. That figure 5 is there. So figure 5 is there. Now, I was not promoted on the sole ground that I did not qualify in the interview because I got 6. I should have got 8. And the pattern which we notice is, my lord, no general category candidate has been given above. And all, my lord, who were disqualified, they all got 6. It can't be, my lord. My lord, from E5 to E6, 11, my lord, failed. They all got 6. And overall, my lord, 94 in the entire exercise. So our basic case is for post-graduation, extra mark was not given. Number 2, my lord, in spite of my good ACR, the same components were there. I was assessed. I was given 56 out of 60. When the same components are to be, or attributes are to be taken note of, for the purpose of interview, they have given us 6. But they must justify, my lord. At least the NSPC, owes an explanation. And thirdly, my lord, how come these ineligible persons were promoted? So therefore, our prayer is, my lord, a review DPC should be constituted and my case should be considered from a date when my immediate juniors were promoted. Yeah. So there should be a review DPC and my case should be considered, my lord, with reference to those persons who were junior to me. So basically my case hinges on, my lord, para 17 E C, para 17 C, D, E, F, para 18 and para 21. Para 21 at page 33, that the petitioner begs to state that the respondents number 5, 6, 7, 8, 9, and 12 had not been posted out of corporate office in their 21 to 24 years of long service with NSPC, which is in contravention to the transfer policy of the NSPC, and they had been closely associated to the member of the DPC and management. DPC in a biased manner awarded more marks in their favor against the interview component in such a manner that they are somehow placed above the petitioner. But in case of the petitioner, he was awarded only 6, less than 8, which is the qualifying mark out of 15. So these are specific cases.
You are relying on which paragraphs?
21, my lord. I'm relying on overall, my lord, 17C, E, sorry, 17C, D, E, and F, 18, and 21. This is where, my lord, our case rests. And the one of the stand taken by the NHPC is, my lord, that against the promotion, there is a provision for appeal. Therefore, we should have gone for appeal. I don't think any judgment is required for that, my lord. In spite of existence of alternative remedy, lordships will certainly look into this aspect, because here is a case where I have been denied equality of opportunity within the meaning of Article 14 and 16. Therefore, my lord, that plea of alternative remedy will not, lie again. And they also would like to contend, my lord, that the jurisdiction is not this honorable court, the Delhi High Court. That is beyond my comprehension, my lord. When I was serving in Ramanadi project, which is within the jurisdiction of this honorable court, therefore to say that I do not have territorial jurisdiction is not correct. So subject to what my learned friend says, my lord, this is my basic case, and I reserve my right to give my reply. Very simple case, my lord. That 6 you could not have given, or if you, my lord, mark is not the issue. Issue is, my lord, the decision-making process. If you apply the policy, thereafter I get 6, then it's okay. But what is there to show that you have applied the policy? At least the circumstances shows that you have not applied the policy, because 10 out of 12 component, I have got 56 out of 60. That is your own people have made their assessment. How can DPC disregard that? And DPC records are before lordships, and they are bound to show it. It's a certiorari proceeding. Therefore, my humble submission is, my lord, lordship will direct a review DPC and the petitioner's case should be considered afresh. That's my humble submission. I have a matter in court number 1, I'll take it. In any case, I think lordship will rise at 10:15. 3:15. 3. So my learned friend can say today or 5 minutes, he can say another day, up to him, man. Diploma.
You want to argue 5 minutes or?
5 minutes will only be introductory. So matter will come, I'll take my lord approximately 1.5 to 2 hours.
Then you
So
fix it.
it's better, my lord, it's better that way because no point just saying 2-3 lines and then.
Mr. K.N. Chowdhury, the Senior Counsel, assisted by Mr. R.M. Dekar, under the counsel to the petition. Also heard Mr. P.K. Diwali, the Senior Counsel, assisted by A.R. Gogoi for the NHPC. Part in part. Please for further hearing when.
Which date? Could it be on Tuesday next? Kindly say.
Any hearing day will be convenient.
Alva will not comment this. Oh, could it be on 9th in that case? I don't know because let this date be. My lord, 9th is Thursday, I understand. So because 7th is a voting day. So we'll be casting our vote. So 9th, I believe, my lord, would be appropriate.
So 9th, my lord, there is a full bench, my lord. And
All
the
right.
senior
In that case, could it
except
be
9 and
14th?
14 will be out of station, except 9th and 14, my lord. Any day.
Then to no way 7th it cannot be
No, 7th election.
election. So it can be, my lord, 16th.
16th. 1/6, my lord, 16th. Deeply obliged.
Okay. Keep dates.
Your lordship, the matter may be fixed on 16th, your lordship. Anyways, your lordship, pleadings are completed as per the
On
instruction.
request made by Mr.
B.S. Dekar, your lordship.
A.S. Dekar, learned counsel for the petitioner.
Your lordship, on behalf of
16th.
Yes, sir. Much obliged, your lordship.
Let it be some other day, my lord, because it may take some time, my lord.
When do you want?
One of the
On request made by the parties.
on 15, my lord.
It's on 15th.
Obliged.
Obliged.
Hello, traffic permission, my lord.
Yes.
Item number 27, my lord.
Yeah.
That may be fixed, my lord.
Okay, on request made by NCM, let us counsel. This one.
Any date, my lord. Short date, my lord. Item number 27.
Then item number 40. 1 minute. 14th.
My lord, short date.
Item number 40 was the hearing matter was there is some urgency. There's an interim order because the petitioner will retire in the month of July. Item 40 was 40 hearing. 40. But the date may be fixed now for hearing. Anybody appearing for the
Yes, yes,
petitioner? Sure is here. Item 40. Yes. But Mr.
R. Salwe, my lord.
R. Salwe, counsel for the petitioner as well as Mr. A. Ganguly, then counsel for the response 1 to 4. When do you want? Any date for the month of May. On request made by parties, list down. When? Any date convenient to look. When is the petitioner retiring? Petitioner will retire in July. You want on a hearing day or any
Hearing day, my lord.
So on a hearing day, 14th May, 14th.
Deeply obliged.
May it please your lordship. Item number 26 may kindly be fixed.
Yes, you're for
Item number 26.
your good name. Your good name.
A. Hussain.
On request made by A. Hussain and the counsel for petitioner. Yes, after
1 week, my lord.
after 1.
That may kindly be fixed, my lord. My lord.
Number 34, your lordship. Hearing matter.
Yes.
It may be listed on the 16, your lordship, which parted matter. Only the department is to produce a document there. I don't know.
You are appearing for?
I'm appearing for the petitioner, your lordship. I'm appearing for the petitioner, item number 34.
34.
Yeah.
On the question by Mr.
AR Google.
Air Google, General Counsel for Petition. Please not.
Let it come on the 16th.
Your Lordship, as per item number 39, Your Lordship, there is an urgency. The petitioner is suffering, is undergoing dialysis, Your Lordship. I pray that this matter be taken up on the Thursday, Your Lordship, 9th of May.
Your good name
D.S. Decca, Your Lordship.
on request made by the. Please not. Fine.